Good morning, everyone. We have 6 cases on this morning's calendar. We'll begin with appeal number 22-2436, Douglas Mann as trustee versus LSQ Funding. Mr. Klein.
Good morning, Your Honors, and may it please the Court. I'm Randy Klein, counsel for Douglas Mann, Chapter 7 trustee for the estate of Engstrom, Inc. Engstrom was a fraudulent enterprise that left over a dozen creditors holding claims against the estate, primarily a claim by Millennium Funding in excess of $10 million and another 12 or 13 claims of other creditors, including several credit card companies, aggregating nearly $250,000. One of the creditors was lucky, LSQ. LSQ was able to get paid when they demanded, prior to bankruptcy, that the debtor repurchase invoices that had been purchased by LSQ and were fraudulent. The debtor was able to obtain new funds from a second creditor, Millennium Funding. The debtor entered into a contract with Millennium Funding. Millennium did not enter into a contract with LSQ. Millennium did not purchase the claim from LSQ. They're not the assignee of LSQ's factoring agreement. They entered into their own agreement with the debtor, pursuant to which the debtor agreed to sell invoices to Millennium in exchange for a purchase price. In order to obtain those invoices, they had to be repurchased from LSQ. In order for that to occur, Millennium directed, the debtor directed the payment to Millennium to go from Millennium to LSQ. This was the debtor's right under the contract to obtain $10.3 million. That interest under that contract is the purchase price for the assets that were acquired.
Mr. Klein, did this payment from Millennium to LSQ have any effect on the funds that the debtor had available to pay the creditors?
From a preference perspective, Your Honor, there was no adverse effect, no diminution, using the words of the earmarking doctrine, on other creditors, but that is not a requirement with respect to a fraudulent transfer.
But you agree that it did not, this payment did not impact the debtor's estate at all. So in other words, the money that the debtor had to pay creditors wasn't impacted at all, other than LSQ.
From a net effect, the answer to that question is yes. In other words, there were multiple transactions. Initially, the debtor obtained the funds. It used those funds exclusively to pay one creditor. So when you net them out, there was no net effect.
Did the debtor obtain the funds? I'm sorry to interrupt. Did the debtor obtain the funds? It looks like the funds went directly to Millennium, directly to LSQ from Millennium.
The debtor obtained the funds pursuant to its contract. That there were only two parties to that contract, the debtor and Millennium.
But never physically had the funds.
There was never a physical transfer. The debtor directed Millennium. Millennium funded the payment on behalf of the debtor and at the debtor's direction to LSQ.
So they structured it, Mr. Klein, as a one-step transaction where the payment went from Millennium to LSQ, but of course they didn't have to. They could have structured it as a two-step transaction, because I think one of the points that you're making is economically it's the exact same. This is new financing to Engstrom, the debtor, right, from Millennium. And they could have structured it where Engstrom received the $10 million, and then the same moment it received it, it just could have wired it out to LSQ to pay LSQ off.
They could have structured it that way, Your Honor.
Right.
But
right.
the fact is that because it was an invoice purchase agreement, the invoices had to be repurchased from LSQ first.
For purposes of a 548A fraudulent transfer, do creditors need to be harmed?
In connection with an actual intent to defraud under 548A, the answer is no.
Right. I thought that haven't courts uniformly held that under 548A that you don't need to ask the question about whether creditors are harmed as a result of a fraudulent conveyance or fraudulent transfer?
That's correct, Your Honor. You're looking at whether there was actual intent to hinder, delay, or defraud. Then, in that case, under 548, you're looking at whether any entity was defrauded, singular. Also, under 544B, where the trustee is stepping into the shoes of a creditor, in this case, Millennium's shoes, under Wisconsin Uniform Fraudulent Transfer Act, that's also looking at actual intent to hinder, delay, or defraud a creditor.
But under 548A, even though you don't have to have evidence that the creditors, there was an intent to defraud the creditors or that they were defrauded, you still have to have an interest of the debtor in the property, correct?
Correct, Your Honor. There needs to be, on the face of the statute, an interest of the debtor in property. But as this court said in the Warsco versus Preferred Technology Group opinion, when assets are transferred, the purchase price for those assets is the debtor's interest in property. So in this case, the debtor's interest in property was the $10.3 million that it received on account of the invoices that were repurchased and then
The new
paid to
financing.
LSQ.
The new financing was the debtor's interest.
Correct, Your Honor.
Yeah. Let me help me with this, Mr. Klein. And I'm asking this to try to understand it as a legal matter. Okay. Why is it so significant in your view as a legal matter that the challenged $10 million payment is a fraudulent transfer as opposed to a prohibited preference? Okay, one of the things that you do in your briefing, okay, is you're emphasizing fraud, fraud, fraud. And you're pointing us to 544 and 548, and you're saying right along with that, this is not a situation where we're talking about an avoidable preference. Can you walk me through why that distinction is so significant?
Yes, Your Honor. It's significant because the district court ruled as a matter of law. Once it went through an analysis under 547, it started there, and determined that there was no preferential transfer by application of the earmarking doctrine, which is not on the face of the bankruptcy code. It's a 100-plus-year-old doctrine that was judge-made. They applied that doctrine to conclude as a matter of law that there was no preference. They then took the phrase interest of the debtor in property, and the district court, as other courts have done, have concluded that when there is earmarking, there is no transfer that's avoidable as a preference. They took that same conclusion and applied it to the fraudulent transfer statutes. That's why we spend a lot of time.
No, I get that. That's descriptive of what happened. I get that. Okay, but why is it then when, in your view, this transaction enters a fraud world? And you're very clear about that. I get that. Okay. Why is it that when we move out of the preference world and we move into the fraud world, that you say everything in that preference world with respect to this equitable doctrine just falls by the wayside? Is there some legal work that the fraud is doing? What's the, in other words, why couldn't you say, as Mr. Schreiner does in his briefing, talking about the same statutory text, let's just overlay the same equitable doctrine on it. And what you're saying in your brief, and what I'm trying to figure out is the why. Mm-hmm. We have a fraud situation here. And you say when we have a fraud situation, we need to apply 544 and 548. And is it that when we enter a fraud world that the code just takes on more strength, or what's going on there?
I think I understand Your Honor's question, and from my perspective, the answer is the purposes of the statutes are different.
Okay, explain that.
The purpose of the preference statute is to avoid a race to assets, and so that all creditors get treated similarly, so no one gets more than another would have gotten had the transfer not been made. There's no actual intent any longer. There used to be, but under the bankruptcy code now, there's no actual intent of the debtor to confer a preference. It's strict liability in a sense. It's not looking to punish transactions that are done with actual intent to defraud. The actual intent to defraud gets at transactions that are culpable, where there's wrongdoing. So there's a different purpose, and in connection when you have like a Ponzi scheme, for example, you're trying to reconcile a different purpose than just a 90-day period with racing to assets. The purpose with respect to fraud is to prohibit those transactions, undo them, and make the third party who received the fraudulent transfer share that loss equally with other creditors of the estate, assuming that they're not also culpable.
Mr. Klein, if the money is clawed back here, what would happen to Millennium? Millennium's not a creditor of the estate, is it? Because its agreement was with LSQ. It didn't. Or correct me if I'm wrong.
I believe that's incorrect, Your Honor. Millennium has a contract with the debtor. They extended the funds. They filed a proof of claim for in excess of $10.3 million. They're the largest creditor. LSQ would have been a creditor, but for the fact that they were paid. If they disgorge the funds, they will then line up as a creditor, and they will share ratably with all other unsecured creditors. And effectively, if you ignore all the other creditors that I articulated, if it was just Millennium and LSQ, both of whom were defrauded by the debtor, there would be $10.3 million in the estate. Both would get 50 cents on the dollar, assuming that LSQ is not equitably subordinated. They would share their loss ratably, and that's consistent with the Supreme Court's precedent in Cunningham versus Brown. And unless Your Honors have more questions for me, I'd like to reserve the balance of my time for rebuttal.
Okay, very well. Thank you.
Thank you, Your Honors.
Mr. Schreiner, good morning.
Good morning, Your Honor. May it please the court, I want to talk briefly, very briefly, but I think it's important about the waiver argument that we made in this case. There's been massive waiver of arguments in this case, starting from issues that were waived, but not raised in the bankruptcy court. The district court pointed that out. The district court pointed out that this was litigated by the trustee in the bankruptcy court as a claim to recover the transfer of money from Millennium to LSQ, despite the fact that, as I guess your questions are sort of asking, both you and Judge St. Eve's questions are asking, what's the difference? And I'll get to that. But this is a case where arguments weren't made that are now being made. Were being made for the first time in the district court. They came to the district court and said, well, really this was about factoring, and factoring is like this. And Judge Ludwig said, no, you didn't raise that below. That's been waived. There have been many other claims that have been raised for the first time in this court. The whole 547C argument that we should somehow infer something from the fact that there's an affirmative defense in 547C. I still don't understand the argument. My point is it wasn't raised below. It wasn't litigated below. We didn't get a chance. The two judges below didn't get a chance to look at that. This court said in the Weber case, which was about a 1992 case, we impose waiver rules for a purpose. We don't want people trying it out in the minor leagues and then coming up here to try their real case. And that's a lot of what's going on here. I just want to make that as a background point, and it arises frequently here. The earmarking applies to 547. Maybe let me just cut through this on the 547. You asked the question, Judge Scudder, why are they emphasizing 548 rather than 547? Why is that so important? Well, the answer is they're going to lose on 547. They're wrong under the case law on 547. There is no precedent from this court saying that the same rules of what an interest of the debtor and property of the estate, transfer of the interest of debtor and property of the estate is under 548. There are a number of them, I count about half a dozen, from other courts of appeals, lots of them from lower courts, including a number of bankruptcy courts, which we cite, saying the same analysis that is used to say what is a transfer of interest of property of the estate applies in 548. After all, Congress used the same words, and that wasn't unintentional. That language wasn't in the predecessor to 548 in the Bankruptcy Act. All there had to be was a transfer of property, and it was often somebody else's property. Now it has to be an interest of the debtor in property of the estate, an interest of the debtor. So it gets back to a difference.
So is that to say, though, I understand that point. same statutory text appears across those provisions. Okay, and I understand the canon about it. The one thing that I've struggled with here is that when I think about the procedural posture that we're in, and I look at the briefing, I look at what went in summary judgment in the bankruptcy court. Okay, it looks to me like your client smelled something quite rotten, and it approached what will become the debtor, Engstrom, and it said, "We want to put these receivables back to you. We want out of this," right? And there's this whole set of events, and there's this whole set of meetings that way, and then you get out when the new financing comes in, with Millennium. That way, Millennium steps into the same exact assets that way, and I'm not trying to get in the middle of whatever's going on between Millennium and LSQ.
Down in Florida.
In Florida,
Where
okay.
the case has been pending.
Right, but it sure looks like, from the standpoint of Engstrom, that there was fraud going on here.
I think very little doubt that there was fraud going on here. The question of whether or not my client, LSQ, was aware of it, I don't think that's established. You say, well, it smells like it. Well, who knows?
Well,
maybe.
no, I don't know if it's established or not, but we're at the Rule 56 stage.
Well,
Right.
which requires that the party opposing summary judgment come up with something more than what they come up with here on that point.
Does it matter if your client knew?
I don't think it does.
Why not?
At all, because we didn't argue this case, and it wasn't decided on the basis of 548A1A or B. It was decided on the first element of the case. Is this a transfer of an interest of the debtor's property?
Yeah, see okay, I struggle with that a little bit. And the reason I do is because I understand the way the transaction was structured.
Right.
But it seems that the structuring is the economic equivalent of a different approach that could have been taken. In other words, Millennium could have paid Engstrom $10 million, and then in the next nanosecond, Engstrom could have wired it to LSQ.
But that didn't happen. And it seems
No,
to me
no,
that
but
that's...
but the point is, it didn't happen. But Engstrom was the one that made the directive, right? Or said wire the money over to LSQ.
I don't know that, Your Honor. For all I know, it seems to make a lot of sense to me that Millennium would do it for its own reasons to make sure that it wasn't caught up.
It's binary though. Millennium's only going to give the money to one of two.
Millennium is going to make the loan or not. And to get back to my point, I haven't done as much asset-based financing as my friend has done through the years. But do people who lend on the security of accounts receivable and other soft inventory sometimes smell a rat, not knowing what it is? I have no doubt of that. I have no doubt that there was something that didn't seem right about this, whether it was a suspicion of fraud or they didn't like something about what they saw. They, as we used to say, threw them out of the bank. That's exactly what happens in this situation. Go get somebody else. And Millennium stepped up and wanted it. It's Millennium, as far as we know, was the source of there isn't anything in the record to establish the debtor made the direction. The debtor acceded to it.
Would it matter with Judge Scudder's hypothetical if this were really a two-step transaction?
Yes, it would.
If it went from Millennium to the debtor and then the debtor to LSQ with the direction it has to be paid to LSQ,
yes,
would it matter?
I think it would under this court's cases, Warsko, which Judge Ripple wrote, and Smith, its predecessor, Judge Cudahy wrote, where Judge Flom dissented. The whole thing was about that. Did it stop in the middle? Was there an opportunity for the debtor to make a choice, these were preference cases, to make a choice to pay off some preferred creditor? And the finding in both cases was yes. And people read the law and they say, people like Millennium, I don't want to get in this mess. I want to buy that loan. I want to take over the position of...
Is that elevating form over substance, though?
That never happens in the law, Your Honor. It isn't elevating form over substance. It's people looking at what the law says, and the law says, and look at the Warsko case. We talk about this. It has to be control. The same thing was said in the Smith case. It has to be control. That's the element of what we sometimes call the earmarking doctrine. The debtor has to have an opportunity to divert those funds to a preferred creditor.
What about the accounts payable? Do the accounts payable go back through the debtor
No.
The accounts payable went to
What happened here was, this was an Article 9 security interest in the accounts receivable, okay? And Judge Ludwig said that too. That's the way that was litigated in the courts below. What happened was, the money went from Millennium to LSQ. LSQ released its security interest, and Millennium's popped into effect. No change in the property of the debtor.
Oh, hold on. So that's okay. So LSQ never held title to the factored receivables.
Bare legal title. The reality of it is they were always leveraged up. They were always secured up all the way through. They were secured up to one creditor, now they're secured up to another creditor.
So when your client put them back, basically said, we want out of this thing.
They just released their Article 9 filings.
That's it. You didn't. That's all you did.
That's all they did. And it's a very straightforward, and it's the way it was litigated down below. It's a very straightforward case. The transfer went directly to the third party, from the third party lender to the old third party. New lender transfers the money to new lender, to old lender, and it's exactly what these cases are about. Even this court, which hasn't officially accepted the earmarking doctrine, has said with respect to the language transfer of interest to the debtor and property in 547, it hasn't had a 548 case, in 547, that looks to whether the debtor had an opportunity to control it. The Smith case was a good case. That's where that there had been what do they call it, temporary credit that the bank had given when the a bad check was deposited in the account, and using the apparent balance in the account, the debtor had written a check to one of its creditors. And the debate between the majority in that case and Judge Flom, who was in dissent, was about whether or not that was enough to establish control. And the majority, Judge Cudahy wrote it, said, well, it was enough to give him the ability to write the check. That's enough. And Judge Flom said, well, no, that was the bank's money, right? It was not an interest of the debtor in the estate. He lost. But they all agreed on the importance of control. That is, the debtor's ability to divert it. Now, whether that's a part of a fraudulent transfer or that's a part of what's the word I want?
It's hard to
preference.
see here. It's hard to see though here how Engstrom could not have said, "Here's the way we want it done."
They weren't in control. They were looking for a new lender. They were doing what they were told. I mean, that's the economic reality of this. This had to be the way that the new lender wanted it structured, or it wouldn't have happened that way. And the new lender didn't say, this is your money, you can do what you want with it. The new lender said, we're going to pay it directly. It is a part of a deal with the debtor. We're going to pay it directly to the old lender. And, you know, if I may, just because we've got some things that were in the reply brief that hadn't come up before, we never heard about the Begier, I don't know whether it's Daubert or Daubert, Begier, I don't know, whatever the case was, the Supreme Court case Justice Marshall wrote back in the 70s, where he basically said those important points being that just the ones that you were asking about, Judge Saini, that, you know, is it the real essence of the avoidance power? And 547, 548 avoidance powers was to not deplete the estate, the coming estate, of ability of something with which to pay the creditors. This $10 million was never going to be in the debtor's estate. The debtor had parted with the ability to control that years earlier when it gave a security interest to LSQ, and then parted with it again. There wasn't going to be anything there for the creditors. My friend says, well, you know, there's $220,000 of other unsecured creditors out there. They're not going to get anything. They're buried under Millennium if he's right, under LSQ if we're right. It just isn't real. I just do want to tell you one other case that I think responds to this point about that we've got the presumption wrong on what happens when the language in the statute is the same. And that's Gustafson versus Alloyd, which you see you nodding.
I know what it is. Yeah.
Judge Cutter, you know, it's a 33 Securities Act case, and the question there is, does the language in Section 10, prospectus, when it's put into Section 12.2, mean the same thing? And the Supreme Court of the United States says, yes, it does. That's the presumption. Had Congress meant the term in 12.2 to have a different meaning than the same term in 10, that is when one would have expected Congress to have been explicit. Congressional silence cuts against, not in favor of Alloyd's argument. The burden should be on the proponent of the view that the term prospectus means one thing in 12 and another in 10 to do strong textual support. That's what the trustee has not done here. Explained why Congress put that language, interest of the debtor and property of the estate, into 548 where it hadn't been before. And that sort of distinguishes, if you will, all of that ancient history from the early part of the 20th century when these cases where that wasn't the language of the 67D or whatever it was in the Act.
I think the trustee attempts to rebut that presumption by saying, at least for the fraudulent transfer provision, that it's inconsistent with the bankruptcy code itself.
I don't think it's inconsistent. It's the first step in what Congress said is a fraudulent transfer claim. You've then got to come along and, yeah, okay, you can make the point that you don't have to show that a particular creditor was hurt under 548A, but you got to get there first. And whether it's in 548 or 544B, the other one.
So what you're saying is that I think what you're arguing is that element, the reality of control, is kind of embedded in that statutory text.
That's exactly right. That's exactly right. And it was picked up for 547 because the statute was different. Congress changed it. And I think in the course of the 45 years now since the bank, I hate to say that because I was practicing under the Act, but in the course of that time, the courts have caught up with the significance in these rare cases of somebody trying to use either 547
So,
or 548.
Mr. Schreiner, is that all? Would you also say, therefore, that to rule in LSQ's favor doesn't require any application of the earmarking doctrine?
That's right. It requires the court to follow the same logic and the same thinking that it did in Smith, that it did in Warsko,
It just requires us to define an interest of the property of the debtor, which appears in
Right.
both statutory
That's right.
provisions.
And they say, well, we haven't done this before. There are other courts of appeals that have adopted the earmarking doctrine, most of them with respect to, have adopted this control notion with respect to what it means to be a transfer of the interest of the debtor. One case that, again, cited in the reply brief, we didn't get an opportunity to respond to, the trustee relies on a case called Moses from the Bankruptcy Appellate Panel in 2000. Well, the 10th Circuit rejected that in a case called Wagon Connect in 2020, which we cite in our brief, and the Bankruptcy Appellate Panel of the 10th Circuit has just said, yeah, that's what happened. Moses is no longer good law. We're not going to follow it. So, I appreciate it. Thank you, Your Honor.
Yeah, very well. Mr. Klein, we'll give you why don't we say 6 minutes just to keep this balanced out.
Thank you, Your Honor. To respond to a couple points that were made by my friend, you asked him, Judge Scudder, about whether this was a financing with LSQ, who owned the accounts. The LSQ factoring agreement, which is in the record, states in paragraph 2, seller shall sell to purchaser as absolute owner, and purchaser shall purchase from seller's accounts. It was an absolute ownership to LSQ. They filed the financing statement because the Uniform Commercial Code requires, when there's a sale of accounts, to file a financing statement to put other parties on notice. It doesn't turn the transaction into a leveraged finance transaction. When Millennium then entered into its factoring agreement with Engstrom, that too was a purchase and sale agreement that required absolute transfer of the accounts. So what happened under the Engstrom agreement with Millennium was they had to repurchase the accounts from LSQ, pay them the $10.3 million, and then simultaneously sell those accounts to Millennium in order to receive the $10.3 million. So that's one point. Second, and importantly, we spent a lot of time in our briefs on statutory interpretation. It's our submission that the earmarking doctrine is applicable only to 547 because it's judicial gloss. Now, this court has said in Kmart, they put a stop to judicial gloss, but the circuit courts elsewhere are in agreement that it's a judicially created exception. It's an equitable exception.
Exception or interpretation?
Exception, Your Honor.
Why?
Because the interpretation of the words transfer of interest to the debtor and property say nothing about control. And there is no diminution requirement on the face of the statute. As this court said in Smith, and again in Your Honor's opinion in Warsko versus Preferred Technologies, the diminution requirement is not found in the statute, but it's been used by courts, and you did not disturb it then, but that was a requirement with respect to preferences, because you're looking with respect to preferences for a different purpose, where other creditors harmed as a result of the transfer. Those requirements, control and diminution, you won't find them in the fraudulent transfer statutes that look at actual intent to defraud, particularly with respect to the 544 action, which goes to state law. The trustee steps into the shoes of an individual creditor. There's no earmarking doctrine under state law. There's no earmarking doctrine with respect to fraud, period. The words are interest of the debtor and property. All this court needs to determine is whether the debtor had a contract interest in these funds. It did. There are no exceptions. Thank you, Your Honor.
Okay, hold on, one question. On going back to what, how does it make sense to think of the earmarking doctrine as an exception?
Well, Your Honor,
that just seems odd. I mean, your answer surprised me. I thought what you were going to say is judicial gloss, meaning it's just an equitable overlay. In other words, when Congress enacted the bankruptcy code in '78, it did it against the backdrop of these equitable principles, and courts have kind of said that one of those principles is this thing we call the earmarking doctrine, and it kind of just, it sits on top of, it provides this kind of gloss on 547, right? It's odd, though, to call it an exception.
Well, Your Honor, I think this court in Smith referred to it in that respect, and the other courts also. The exception is not a statutory exception. It's a judicial exception. It was federal common law when it was created, and originally it came out of the diminution doctrine, which was federal common law. And so is the point then that you shouldn't put the gloss on, just focus on 548. You shouldn't put the gloss on 548 because 548 is dealing with an altogether different situation of fraud. That's correct.
And an equitable doctrine that's about fairness and about trying to avoid double payments by guarantees and guarantors and what have you. It just doesn't have a place in 548. Is that the point?
That is the point, Your Honor, and the focus primarily is that doctrine came out of a notion of diminution, looking at whether the other creditors got less as a result of the transfer. And if there's no diminution, so the courts looked at over 100 years ago, they determined there to have been no preferential transfer. Diminution is not a component of fraud, it's of actual intent to defraud. The concept around diminution has applicability when you're looking at constructive fraud and reasonably equivalent value and things of that nature, but not with respect to actual fraud. So the basis of the judicial doctrine has no application to fraud.
Okay, one final question, if you don't mind.
I don't mind.
Okay, in the if we altogether changed the fact pattern and we assumed, contrary to the way this has been briefed and everything, that LSQ had not a clue that something was amiss at Engstrom, they just wanted out of the deal, and they exercised a contractual right, but they didn't have any sense that, what is this entity, Next Extra or whatever it is, Next Era, and the individual running Engstrom, that it was not fishy. Does the legal analysis change?
Not with respect to the issue that's on appeal in this court. The legal analysis does not change because LSQ was lucky in that respect, even if they didn't know. The code looks to actual intent to defraud. The intent to defraud is not the transferee's intent. It's the debtor's intent.
So why so much emphasis then in your briefing in the bankruptcy court on Engstrom acting in concert with LSQ? What's the legal significance of that?
I think it has multiple parts to answer that question. Part of it was, if you accept the notion that was argued below, and we've stated in our briefs here, that the earmarking doctrine is an equitable doctrine, the argument was made in the courts below that if, as an equitable doctrine, these facts matter about whether the beneficiary of the payment was somehow in cahoots with the debtor. We aren't making those arguments with respect to this appeal. We're focusing exclusively on whether there was a transfer of an interest in the debtor, and we have reiterated the pleadings below with respect to alleged participation, but that goes to, as we noted in our brief, if LSQ disgorges, they will become a creditor. Even if they were a good faith transferee, they will have that argument as well. If they gave value, they will have that argument as well. But if they can't meet that test for a good faith transferee who gave value without knowledge of the voidability of the transaction, which we believe they won't be able to meet, they will have to disgorge. They will then line up and receive a pro rata share of the estate unless they get equitably subordinated based on their participation in the fraud. That's another step. If that occurs below.
Okay, very well. Mr. Klein, thank you. Mr. Schreiner, thanks to you.
Thank you, Your Honor.
Appreciate the high quality of the argument and the briefing. We'll move to our second case of the morning. Okay, our second case is the United States versus Chad Griffin and others. 213326 is the appeal number. We're going to begin with Mr. Bont. Good morning.
Good morning, Your Honors. May it please the court. My name is John Bont. I, along with co-counsel Ms. Garce, represent the defendant, Carrie Agee, and I will be arguing the defendant's joint arguments on appeal. The government's theory of property fraud in this case is legally invalid. The government recently conceded as much to the United States Supreme Court in a different case, and it requires the reversal of all counts under this court's decision in United States versus Barrero. In this case, the government's theory of property fraud was that the defendants defrauded the SBA out of its right to control its risk of loss by procuring loan guarantees that the SBA would not have issued but for various agency rule violations and misrepresentations.
What are you relying on, Mr. Bont, to argue that that was the government's theory of the case? I've looked through the arguments, I've looked at the jury instructions. I don't see anything where the government was arguing to the jury, or in the indictment even, that this right to control theory, which I realize that theory may have some, it may be under a cloud at the moment, but I don't see anything that supports your argument that that was the government's theory of the case. It seems like you are trying to argue that now because it's part of the Simonelli case before the Supreme Court.
The government argued, particularly in closing, cited on page 8 of our reply brief, it's page 1586 of the transcript, that a loan guarantee is property because it's the right of the SBA to guard against its risk of loss. So that was the...
But a loan guarantee, the SBA's guarantee, that's a separate question than the right to control the process.
Well, a loan guarantee is only a right to control, Your Honor. It's a right to control.
No, it's not. It's a loan guarantee, and the case law says this, is a guarantee you're going to pay money.
It's a promise to pay in the event that some conditional fact happens. And the way that the government presented it in this case is that it never would have issued the loan guarantee but for misrepresentations and agency rule violations. So
are you arguing that any time there's a loan guarantee, it's a right to control case?
I think Simonelli is going to answer that question, quite frankly, Your Honor, because Simonelli is also a contract case where it's dealing with a contractual obligation to pay.
I'm not so sure Simonelli's going to take on the loan guarantee and the right to pay money, especially given some of the comments during oral argument.
It's possible that they don't, but again, Factually, it's dealing with a contractual obligation to pay, which is what a loan guarantee is. And
So I'm sorry to interrupt, but let me come back, Mr. Bont, to your argument. Is that the only piece you are relying on for your argument that the government relied on a right to control theory here? The statement you just gave on page 8 of your reply from the closing argument?
No, Your Honor, the entire case was based on the agency's right to control its interpretations of its rules.
You agree the jury was not instructed on any right to control theory?
That's correct, Your Honor.
Okay.
And
Unlike
in
Simonelli,
Barrero.
where the jury was clearly instructed on that.
But in Simonelli, they're not arguing that the jury instruction was invalid. It's also before the court on a Rule 29 motion.
But
which
it's
is
the
how they
theory
brought
of the
it.
case. I understand it's not a jury instruction case there, but it supports their theory of the case because that's what they argued to the jury and that's what they had the instruction on.
Correct. It was a theory of the case instruction. However, regardless of whether or not a theory of the case instruction was given, which it was not in this case, the government shouldn't be permitted to bring an invalid legal theory in front of the jury in any respect, whether it's argument, presentation of evidence, or otherwise, which is what happened in this case. And in
So,
Barrero,
Mr. Bont, can I in keeping with the same question, so I think it's the same question, it's just going to be in different words.
Okay.
Okay? And that is this. I think your argument is fair that the government did focus on the SBA being defrauded as to who it would issue guarantees to, because that's all the evidence that was put in about being less than candid, making misrepresentations about the purpose of the underlying loan proceeds. I think that's totally fair. Okay? But that seems incomplete to me. That there were other aspects of the government's evidence, and that is what you're focused on, and I totally understand why, because of the right to control and the possible legal vulnerability around that. Okay, you're very much focused on that kind of front end, if you will, right? And you're saying what the government basically was arguing, and what it proved is that the SBA wasn't getting candid information. And because they weren't getting candid information, they were making tainted choices on who to give. And you'd say, well, that sounds like a lot of the right to control. That sounds like Cleveland, right? That's why you're arguing that. Okay. My point is that there's a back end of the case as well. And the back end of the case is that there was also fraud in getting the SBA to honor the guarantees. In other words, I don't know what the dollar amount is, you will, but ballparkish $10 million of actual payouts here. Okay? Mm-hmm. And to get the SBA to pay out, I thought the evidence showed you had to apply, or you had to request that the SBA make the payout. And that in that paperwork and in those transmissions, the misrepresentations were renewed that way. So if there's a back end of the case, doesn't that distinguish this from just the front end cases, if you will, my words, not yours, okay, on right to control liability?
if that were the only theory that the government would have pursued in this case, I wouldn't be up
Meaning
here
the
arguing.
back end?
The back end, where there was actual money being
Okay,
paid
but
out by
going to the
SBA.
point Judge St. Eve is making, if the jury's properly instructed, and nobody has an issue with the jury instructions around the fraud, the 1343 or 1349 instructions that way, aren't we just looking at the totality of the evidence against the standard of review that you face and asking, could a rational jury, considering the front and back end evidence, reach verdicts that are legally sound, with this court fully mindful of what's in front of the Supreme Court in Simonelli?
No, because of this court's decision in United States versus Barrero. Similarly,
Barrero, though, is different. Barrero, by its terms, involved flawed jury instructions. The jury there, you'll remember, I mean, you're mentioning it, you'll know this. The jury there was given kind of two different instructions. And what the court said is that's problematic because we don't know on what basis they returned that verdict.
and that's the same situation we have here. The instructions were
The
broad
premise
enough.
is different.
Well, but just because we didn't argue jury instructions on appeal doesn't mean that the Rule 29 motion goes out the window. That's how Barrero was raised. That's how Simonelli was raised. The problem is that when the instructions are broad enough that we cannot determine on appeal whether or not the jury convicted on a legally invalid theory or a legally valid theory, Barrero says the correct outcome is reversal. And that's what happened here. Now, in Barrero,
But
there
the
was
jury
no
was
question.
instructed on a scheme to obtain money or property through the guarantee. I don't know how that is broad enough that they could convict solely on this right to control theory.
Yeah, on front end only. Right, the evidence of the back end fraud is there in the case.
And there was evidence in Barrero as well of taxpayer fraud, that the taxpayers were defrauded because sales taxes weren't properly remitted, because improper prices were put on the licenses at issue. And this court said that that's a problem. The government could have pursued that theory below exclusively. And there's no question that the government could have pursued exclusively the payout of money on the guarantees as an actual money interest for purposes of wire fraud. We would still have issues with it, don't get me wrong. But that's not what they did here. I mean,
So,
four
Mr.
of
Bond,
the
I want to
nine
make sure I understand your argument. Are you arguing that any time someone submits fraudulent documents to obtain a loan, if there's no payout on it, that's a right to control theory that would potentially fail if the Supreme Court finds that right to control is not a valid property interest?
Correct, Your Honor. If the government's sole focus is on that guarantee, that promise to pay in the event of future circumstances, that is synonymous with the right to control. That's why the prosecutor argued it as such in this case.
But when you say the government's only focus, there's a lot of evidence that there were guarantees that were paid out against the backdrop of renewed false representations.
4 of the 9 loans at issue in the case did not default, so there was no payout.
Right.
For 5 of them, there was some
Is that
payout.
where the 10 million comes from, or ballpark 10 million comes from the 5, right?
I don't recall what the precise number is, but it comes from the 5. You're right. However, with those loans in particular, as we raised in our sentencing arguments, there was no proximate causation nexus between the misrepresentation and the defaults at issue.
So I want one follow-up question before we switch to topics, if you're going to. Under your argument, would the Supreme Court have to overrule its opinion in Pasquinito in order for your argument to be sound, where they found that the right to be paid money has long been thought to be a species of property? That makes sense given the economic equivalence of money and a money legally due?
Well, I believe that case deals with a right to pay money, which is different than just a conditional
But
obligation.
there they found that the right, again, the right to be paid money, which is a guarantee, as opposed to the actual payout, was the property interest, which would be one of the pieces that has been argued here, that the guarantee, the right to be paid, is what the property interest is.
I would expect that the Simonelli opinion would considerably narrow that decision that Your Honor references.
That they'd have to actually pay out money.
Correct. I think even this court's prior decisions, when it talks about the right to control risk of loss, mentions that actual or intended financial loss is a requisite proof in those particular cases, which the jury, of course, was not instructed that it had to find in this case. And as a result, we have other arguments regarding the reasonable foreseeability of the loss and whether it was caused in fact or in law by the misrepresentations. But shifting gears, if I might, to an issue that you raised, Judge Scudder, the government, although it charged a conspiracy to commit wire fraud affecting a financial institution, the object of the conspiracy that the government proved at trial was really different. It was the object of the conspiracy, as found by the district court judge below, was to defraud the SBA, which is different than a conspiracy to commit wire fraud affecting a financial institution. It's a different object. In this case, there was no evidence, and the government didn't argue that the defendants intended to affect a financial institution or that financial institutions were, in fact, affected.
Is it your argument that in order to prove that the fraud affected the financial institution, that you have to show that the defendants intended to defraud the financial institution?
Only on the conspiracy count, Your Honor, because the object of a conspiracy is part of the conspiracy charge. It's something that the government has to prove.
But the object they charged here is the SBA. The object of the conspiracy was the SBA as charged and as argued. The effect of the financial institution just brought in the other federal statute.
I would agree with Your Honor that as argued, the object of the conspiracy in this case was to affect the SBA, but as charged, it was a conspiracy to commit wire fraud affecting a financial institution, and the government even argued, we filed motions to dismiss early on in the case, and in response to those motions, the government even argued that it's a separate conspiracy. The object of the conspiracy is different than the other conspiracy that the government initially charged in this
Any
case.
court endorsed what you're saying? What would you point us to where a court has held that for 1343, 1349 purposes, where there's an effect on the financial institution, that the charging instrument and the proof has to focus the object of the fraud on the financial institution as opposed to just the effect? What court has held that?
Specifically, Your Honors, Cody Akis versus the United States was the Supreme Court decision that said you can't prove two conspiracies when you've only charged one. And so
No,
That's a
there's-
separate.
Yeah,
I'm
go
sorry.
ahead.
Go ahead. No, go ahead. That's a separate argument then.
Well, Your Honors, the object of a conspiracy is an element that needs to be proved at trial. And in this case, the government didn't prove that.
Why isn't the
object, that it
legal
was-
analysis no more complicated than that? We'll give you time. Don't worry about it. All right. The object of the conspiracy was to defraud the Small Business Association. That's what it was. Okay. Now, it just so happened that there was an effect upon financial institutions, so we're going to charge it accordingly. Why is that legally problematic if the case is approached that way?
Because the object has to include everything that the government stated that the object was in the indictment, which wasn't just to defraud the SBA, it was to commit wire fraud affecting a financial institution. And affecting a financial institution has been defined by this and other courts as subjecting the financial institution to an increased risk of loss. And the government just did not prove that that was part of the object. That wasn't its focus at the case. It was an incidental byproduct, and that much was presented by the government at case, but not that it was the object. Finally, Your Honors, with regards to defendant's sentencing argument, and I mentioned this earlier, remand for resentencing would be required in this case in any event because the district court judge employed an improper loss methodology that focused on but-for causation and not legal causation or proximate causation as the common law calls it. The government argued and the district court based its loss analysis on the premise that the SBA never would have guaranteed the loans at issue had it known of the defendant's misrepresentations and rule violations. But as this court held in United States versus Luce, that is but-for causation. It's not proximate causation.
Mr. Bond, you mentioned that I think it was 4 of the 9 loans did not default, am I right?
That's correct, Your Honor. 4 of the 9 loans did not default.
What is your position with respect to the amount of restitution due on those loans?
On the loans that did
That
default,
did not default.
on the loans that did not default, there should not be restitution, Your Honor, because there was no loss. There was no actual loss.
And the position of the district court was?
Similarly, that there was no restitution ordered on the loans.
So the only restitution was on the loans that did default?
That's correct, Your Honor.
Okay, thanks.
In particular, one of the loans involved a $50,000 misrepresentation about whether or not an equity injection was going to be made by the owner. And the $50,000 misrepresentation did not proximately cause the loan to default several years later.
Mr. Bond, in looking at the sentencing transcripts, although the court may not have used the word proximate cause is if the defendant knew or reasonably should have known and it was reasonably foreseeable. And if I look at the transcripts of everybody who was sentenced, the court specifically found with respect to, I think, everybody, that they knew the risk of the fraudulent activities and they were aware of the likelihood that the that they would default. Why isn't that sufficient?
Your Honor, I see my time is up. Can I
That-
briefly answer Your Honor's question? Thank you. There are different sentencing transcripts in this case, Your Honor. I'm intimately familiar with one where the district court judge did not make specific factual findings regarding the misrepresentation at issue, proximately causing or at somehow increasing the risk of default.
But do you agree that even if the court didn't use the word proximate cause, if the court made a specific finding that a defendant knew the risk of their fraudulent activities and were aware of the likelihood that the SBA borrowers might default, that is sufficient for proximate cause?
There has to be a tie between the misrepresentation, the quote-unquote fraud, and the actual loss. So if the district court's analysis were to tie that in, then in terms of reasonable foreseeability, then yes, but the district court judge didn't do that here. Thank you, Your Honors. I see that my time is up. I'll pass
Okay,
the argument
very well.
to Ms. Masters.
Good morning, Your Honor. Ruth Masters and I represent Defendant Chad Griffin. And today I'm going to address his arguments in his individual brief regarding the application of the sophisticated means enhancement and rest on the briefs for all the other issues, although I do want to call to the court's attention that the government has conceded there is an error in his conditions of supervised release so that remand is required at least.
Is that with respect to the mental health?
Yes.
Yeah, okay.
The court here committed procedural error in applying the sophisticated means enhancement to Mr. Griffin in two different ways. It erred in its interpretation of the sentencing guidelines and by relying upon clearly erroneous facts. The sophisticated means enhancement has two limitations. It's limited to the defendant's conduct only as opposed to conduct in the scheme as a whole, and the conduct has to be sophisticated, meaning that it has to be intentionally engaged in by the defendant to conceal the fraud instead of conduct that is the fraud itself. Legal error occurred here when the court unequivocally stated that it was, quote, not just looking at the touch-tone loan or any particular loan, but the overall scheme to evaluate sophistication. Now, my client was only involved in two loans, Touchton and Larson, so looking at the overall scheme was entirely erroneous under the current sentencing guidelines. And even if that alone does not warrant remand to resentencing, the court also relied upon clearly erroneous facts when it attributed conduct in the Larson loan to Mr. Griffin in terms of preparing new documents at the redemption phase of the guarantee, when in fact the record is clear that he played no role in that. So this court should reject the government's suggestion that it can affirm, because in the sentencing transcript the judge references Touchton and Larson, and in the government's opinion the district court could have relied upon those two loans just to impose the enhancement. The fact is the court didn't rely upon Touchton and Larson, and it stated that was not what it was doing, so there is clear error and remand is necessary. I want to briefly
Ms.
address...
Masters, can I just clarify one thing, please? The court has to make a determination that sophisticated means were used in the scheme and then look at the defendant's specific conduct. I completely agree with that. I want to make sure I understand your argument. The court did state it was looking at the overall scheme to evaluate sophistication. Why wouldn't that just be a comment on finding the first piece of the sophisticated means analysis, namely that sophisticated means were used for the scheme, and then the court went on to look at your client's specific role?
Because, Your Honor, the court, because it's not, because I guess we would disagree with Your Honor's statement. The sophistication analysis does not require looking at the overall scheme, and in fact the Wayland case, which the court cited to, has been replaced by the current version of the guidelines, which says you only look at the defendant's conduct to evaluate sophistication, and you don't look at the overall scheme. That's the plain language of the comments in the sentencing guideline. So I would respectfully think that the premise here is that the court shouldn't at all have been looking at the overall scheme.
I certainly agree that if simply the scheme involves sophisticated means, that alone is not sufficient. And I agree the case the court cited, the guidelines have been updated since then. But it seems the court, that initial statement was just saying there is sophisticated means here, but then it went on to look at Mr. Griffin's conduct in particular.
Well, let me make two responses to that. One is, I think we can't know that, right? As a reviewing court, I don't think the court can know that when the court specifically states that's not what it's doing. It's looking at all the scheme as a whole. So how do we know that it really only applied the enhancement because of Mr. Griffin's conduct? But the other point I'd make is the court's wrong on the conduct she's attributing on the facts to Mr. Griffin. The court comments that he is responsible for conduct in larceny, and he unequivocally is not. He didn't prepare false documents that the court is attributing to him. In the Touchton loan, the court refers to the use of a bridge loan structure, but in fact the bridge loan structure is actually disclosed to the SBA at the time of redemption. So the documents, even if there was some concealment regarding the bridge loan in the initial application, at the time of redemption, when the purchase demand kit is given over to the SBA, it shows that money went to pay the BBB bridge loan off, and that was not an authorized use. And there is even a specific page that references that it went to taxes and penalties, and those sites are in our brief, but I think it's Government Exhibit 126 at 217, 218, and there's other pages cited as to that.
Okay.
Thank
Very
you, Your
well.
Honor.
Thank you. Okay, we'll hear from the government.
Thank you. Good morning, Your Honors, and may it please the Court. Andrew Lang for the United States. The defendants were charged and convicted of a single conspiracy to defraud the SBA that affected financial institutions. They conspired to deceive the SBA regarding the eligibility of certain loans and borrowers for valuable SBA guarantees, promises to pay money in the event of default. And as a result, they were able to obtain those guarantees, and in some cases payments on those guarantees, that they could not otherwise have obtained. So we ask this court to affirm in all respects except Griffin's amended judgment.
You know, Mr. Lang, when you first open the briefs in this case, the first thing that hits you is this the way they usually charge this conduct?
It's a fair question. I think the answer is yes, because when it comes to a government loan guarantee, and we've seen this in some of the other cases that we cite in our brief, like Medeo out of the DC Circuit, it makes sense to charge that as wire fraud because the government is being deprived of a property interest in the guarantee. And then, of course, also, as Judge Scudder put it on the back end, is being deprived of money as well. And so the right to control gloss or lens on this case, I don't think adds anything to the analysis because this is a traditional theory of money or property fraud. The defendants deceived the SBA in order to obtain its property in the form of guarantees, as well as its...
usually charge the effect on the financial institution aspect of the charge here, or they just usually charge the fraud on the SBA and leave it at that?
I think the charge could have been brought either way. I don't know statistically how often it's one or the other.
You'd expect that the arguments we're seeing before us today by the defendants would have been challenged by a lot of other lawyers over the years, and there'd be a lot more in Fed second, third, and fourth than there is. It just gives this whole case a kind of suspicious whiff, you know, when you look at it. What's the government up to here?
Well, I think this is a prototypical theory of wire fraud. I agree that affecting a financial institution doesn't arise as often in the cases as pure vanilla wire fraud, but with respect to the defendants' arguments about whether the defendants had to intend to defraud a financial institution separate and apart from intending to defraud the SBA, this court's case law, in particular Marr, which we cite in our brief, forecloses that argument. this court has explained that Congress, in protecting financial institutions from wire fraud, intended to extend the statute of limitations where a scheme to defraud affects financial institutions.
What does the defendant have to know about the financial institution? Does it have to have the intent to defraud that financial institution?
No, and this court has said as much in Marr in discussing the jury instructions in that case. This court explained that the district court was correct to instruct the jury you have to find intent to defraud, but you do not have to find intent to defraud a financial institution.
What do you have to show? Do you have to show anything with respect to what the defendant knew about the financial institution?
Not according to Marr. The financial institution has to be affected in the sense that it has to be exposed to some new or increased risk. And the jury instructions in this case were consistent with the jury instructions that this court signed off on in Marr. You have to have a scheme to defraud, of course, intent to defraud, use of the wires, and that scheme in a case involving affecting a financial institutions has to affect a financial institution by exposing it to new or increased risk.
Tell me about the government's evidence that there was an effect on a financial institution here.
Sure. So the most straightforward evidence of that came from SBA witnesses, notably Teresa Hendricks, toward the beginning of the trial, who testified about the purpose of the SBA guarantees. The whole point of the SBA guarantees, according to Hendricks, is to lessen the risk for banks, to encourage them to participate in lending for the small businesses that the Small Business Administration is set up to serve. Kelly Ayers, a cooperating witness who worked at one of the banks, testified that the reason that banks go out of their way to try to get these loan guarantees is because they greatly reduce the bank's risk when it comes to making these loans to borrowers that might otherwise have trouble getting credit.
And it's fair to say that the banks are, in the normal course of events, active players in getting the SBA.
Absolutely. And in this case, there was ample evidence, including from that cooperating witness, as well as ample documentary evidence, that the bankers were involved with BankServe in applying for these guarantees and in some cases making misrepresentations in order to get the guarantees.
What's the government's position with respect to the actual impact on the banks in this case? What's the government's position on what has to be shown, if anything?
So the government's position is that the most straightforward way to look at it is the government had to prove that the banks were exposed to a new or increased risk of loss. And in this case, there was testimony, including from the witnesses that I mentioned, that the deception of the SBA made it more likely that in the event of a default, which did actually come to pass in several of these loans, the SBA would discover the fraud and refuse to pay out, leaving the bank holding the bag. So that was the risk to the financial institutions.
It was the risk, and that's how you encompass the, what is it, four loans that did not default.
Four did not default, correct. Yes, but the risk existed in all of those cases, whether or not it materialized into an actual loss. And this court has held that you don't have to show that the bank actually lost money. I believe that's from Serpico. You have to show that the bank experienced a new or increased risk, but not an actual loss necessarily.
So in a situation like this where the front end fraud was exposed and then the misrepresentations were renewed in requests for asking for, was there any evidence before the jury that then guarantees that were actually paid on were then subsequently voided and the SBA turned to the banks to recoup?
I believe there was testimony as a general matter that that's what would happen if the SBA discovered fraud. And I know with respect to one of the loans, the SBA initially tried to send out an $81,000
That's why you answered Judge Ripple the way you did. Because if that would happen, you'd say a financial institution is exposed to some risk. It's financial risk.
Yes. Yes, exactly. I also want to touch on the right to control theory generally. I agree with the premise of Your Honor's question, Judge St. Eve, that I think the guarantees themselves should be seen as property under Pasquantino. They are a promise to pay money.
Do you agree with Mr. Bont that that is at risk with Simonelli?
I don't think, I hate to prognosticate when it comes to the Supreme Court.
I understand.
I doubt that Simonelli will overrule Pasquantino or the premise of that decision that a promise to pay or the right to be paid money is a property right. I would be surprised if that happened. But of course, Simonelli might say a lot of new things about fraud generally. And I would say we don't oppose the prospect of this court potentially holding this case in abeyance until Simonelli is decided, because that is possible, but I doubt it.
So I thought that the clearest distinction, if there's legal infirmity with the right to control, we'll all stand by and await word from the Supreme Court on that. But if there's legal infirmity, it's got to be with respect to what I'm calling this kind of front-end fraud here, right? On the SBA's right to make decisions untainted by fraud as to how it issues guarantees. Now, to be sure, the point that Judge St. Eve is emphasizing is correct. This is not a gaming license like we saw it, right? Or making decisions regarding traffic on a bridge or anything like that. A guarantee is a different, has a different characteristic, much more of a characteristic of a financial obligation that way. But the case is not. I don't read the evidence as just being front end evidence. I thought that the way that this was both charged and then proved was that the fraud ended up having consequences here. That there, I don't know if I got the dollar amount right, but in the neighborhood of $10 million of guarantees that were paid out in situations that should not have been paid because the underlying the proceeds were being borrowed for impermissible purposes that didn't align with the SBA's guarantee protocols. Am I wrong about that?
I don't think so, Your Honor. I completely agree with a couple of things in Your Honor's question. So first of all, I think Your Honor is correct that if there is a so-called right to control issue with this case, which we don't think that there is, I agree that it wouldn't be with the money that the SBA actually paid, the back end of the fraud. And at most...
And isn't that part of the conspiracy that's embodied
Yes.
in the offense of conviction?
Yes, and the indictment, I think, makes that clear. The indictment alleges that part of the conspiracy was, in the event of default, to send these demand letters to the SBA, make sure that it didn't discover that the guarantees had been fraudulently obtained, and make sure that it would pay out. So yes, I agree with Your Honor that money was, from the beginning, part of the way that the government charged and proved the conspiracy. That was part of the object. The point I also want to make is that the guarantees themselves are still a property interest, and the right to control theory doesn't change that because they are straightforwardly a promise to pay money under certain circumstances.
As you say, that distinction is that, at least in the case laws as we have before us here, that the financial guarantee of the SBA is not the same as the Louisiana gaming license in Cleveland. They are altogether different.
Yes, exactly. And Madeoi from the D.C. Circuit, which we cite in our brief, makes that point and distinguishes a number of older cases having to do with regulatory interests. Obviously, that's an older case. I think it predates Cleveland and, of course, Kelly. But the D.C. Circuit distinguished a loan guarantee from, I think the examples were the FAA issuing a pilot license or a state issuing a video gaming license or something along those lines. Those regulatory interests are not the same as a promise to pay money. Those are more ephemeral, intangible. These are the government's property rights. And it would be the same case if the loan guarantees were being issued by a private entity or a nonprofit. It would still be a property interest.
Yeah. In the interest of time, can I switch you to a different topic?
Please.
I have some concerns about the conviction of Matt Smith.
Sure.
And I want to focus in particular, sorry for the specificity, but one of the key pieces of evidence is the email that's in Government Exhibit 125. You know what I'm talking about?
If you're honest,
This relates to the Touchton Industries matter. Mm-hmm. That seems to be, if there's proof that Mr. Smith was a member of or joined a conspiracy here, that seems to me to be the strongest evidence, and I have some concerns about whether that evidence is enough.
Sure.
What's your response to that?
So our response to that is that the government presented sufficient evidence to prove that Matt Smith joined the conspiracy. We agree with the district court in ruling on the Rule 29 motion that this was a closer question than it was for the other defendants. But there was enough there to show his knowledge of the conspiracy.
What's the enough, though?
So a few things. So first of all, there was evidence of his knowledge of the conspiracy's objectives and of the methodologies that the conspiracy employed. And there was also some evidence, again, less than with other defendants.
Yeah, can you be as specific as you can? That's going to really help.
Sure, I understand, Your Honor. So a couple of things. So first of all, with respect to Larson Cement Stone, Griffin sent an email to others, including Matt Smith, that payroll tax payments would be disguised as working capital. With respect to the Rogers Finishing Tools loan, this is around page...
Yeah, okay, keep going. I mean, that's the deal. That's the situation where his signature's forged.
Right, there was much debate about that on cross-examination. We're not relying on the signature necessarily, but that the participation in the email chain bolsters the circumstantial evidence that he was aware of everything that was going on, and he was part of the cast of characters who were engaged in this longer-running conspiracy. With respect to Rogers Finishing Tools, and this is around page 993 of the transcript, although AG was doing most of the talking on the call with Mr. Crawford, he said that he relied on Matt Smith and AG together to understand the SBA's rules, to follow those rules, to apply for the loan, despite the fact that...
He didn't say anything during that call, did he?
So the testimony, I think, was that AG did most of the talking, and that the idea to use the SBA loan proceeds to cover the $50,000 equity objection came from Matt and Carrie. I think
During that call?
I think that was the testimony. I don't have that page.
Yeah, I got the testimony right in front of me. It says on the who suggested that this was with the 50,000 answer on the phone conversation with Matt and Carrie. This is Crawford's testimony with Matt and Carrie. Carrie was talking on it. Okay, so yeah, who did the majority of the talking on this phone call? Answer: both talked. Carrie was the majority of the conversation, though.
Yes. Yes. So I think they were both on the phone discussing the concept with him. The evidence clearly is that AG was doing most of the talking, but I think that bolsters the inference that Matt Smith was involved in the conspiracy. There was also other testimony, which we summarize in our brief at page 50, that Matt Smith was one of the members of the cast of characters who were involved with interacting with staff at the SBA, who were involved in moving some of these loans forward.
I thought the SBA people didn't have a clue who he was.
Not all of them. I believe at least one of them testified that they interacted with him.
It just being a member of the cast of characters doesn't get you there.
I agree.
That's like a mere presence argument.
Yes, I certainly agree with Your Honor, and that we're not relying exclusively on membership in a cast of characters. But although, again, the evidence is less overwhelming with respect to Mr. Smith than some of the other defendants like AG or Isley, we think that it is enough for a jury to reach the conclusion that he knowingly participated in the overarching conspiracy. He knew what the conspiracy was up to. He knew what kinds of false representations were being made to the SBA.
What do you base that upon his prior marriage?
No, we're not relying on the marriage by itself. But there are, again, the communications that we summarize in our brief, where he's receiving several emails, he's involved in the conversation with Mr. Crawford. So again, it's...
Is there any evidence that he's actively doing anything? I understand your argument that he's on these email chains, which might support knowledge of what's going on. But what's your best evidence that he is taking an active involvement in the conspiracy?
So I think with respect to the Touchton Industries loan, his proposal of the bridge loan structure helps bolster the evidence of his active involvement. So there, I think there is evidence that he
See, I worry about I'm glad we're having this dialogue. I worry about that because there in that same email, okay, he writes, this email's been copied to Carrie Agee Smith of BankServe Partners, also for their concurrence on the structure, right? So, and then, somebody from, what is this? I don't remember the name of the company here. Ridgestone of the bank. Ridgestone weighs in. And the guy from Ridgestone, Bruce, somebody, is saying, does this follow the terms of the SBA's authorization? It just doesn't look like Mr. Smith is saying, hey, I know that that line item for the $157,000 to the Internal Revenue Service, that's to improperly cover payroll taxes. But we got to keep quiet about that. Because if we tell the SBA that we're not going to get the guarantee, that's prohibited. There's nothing like that here.
Yeah, I think the evidence speaks for itself. I think the evidence supports at least the inference, allowing a rational jury to make the conclusion that Mr. Smith participated knowingly in the conspiracy.
Yeah, what I worry about a little bit is that he got precisely wrapped up in the cast of characters. But being a member of a cast of characters does not mean his guilt was proven beyond a reasonable doubt.
I understand Your Honor's concern. And again, I don't think that our position has been or is now that his membership in the so-called cast of characters is enough by itself. I think his involvement in these communications over time supports the inference of his participation in the
It's
conspiracy.
the involvement part that gives me pause. That I understand he is CC'd on some of these communications and he was on the call, which may be sufficient to establish he had some knowledge of what was going on, but it's the next part of his active participation in it that is pretty weak.
I understand that, Your Honor. And again, I would submit on our brief on that. I think we put forth the evidence that there is in the record.
Okay. No. Are you done with, I want to switch topics to something that I know it's not as significant as some of these other points, but the defendants have argued that the guarantee fees should not have been included in the actual loss. And you didn't really address that head on in your brief. Do you agree? And they've admitted it's harmless because it wouldn't impact the actual loss amount or the guideline calculation. First question, do you agree that the guarantee fees are more like finance charges and should not have been included in the actual loss?
So I don't agree that they should not have been included in the loss because of the operation of the government benefits rule. And I want to make sure that I take a moment to clarify something that the defendant said in their reply
Separate and
brief.
apart from the government benefit rule, do you agree that finance charges aren't included in actual loss for guideline calculation?
Right,
That's a separate issue having nothing to do with the government benefit.
Yes, I agree with Your Honor there. So absent the government benefit rule, I think the defendants would be correct.
Okay. So do you think that they were incorrectly included then in the actual loss? I
because of the government benefits rule. And that's where I want to clarify the argument that the defendants are making in their reply brief about Leahy and the amendment to the guidelines, if I might just have a few seconds.
Yeah, go ahead.
The application note defining the government benefit rule, when it comes to unintended recipients of government benefits, has been consistent in substance since the version of the guidelines that Leahy was interpreting up until today. That guideline tells courts if somebody is receiving a government benefit that has been diverted from intended recipients, and now I think it says diverted to unintended recipients, the whole amount of the benefit is loss, not net any fees. So Leahy interpreted that previous version of the government benefit rule, which is substantively unchanged. The amendment that the defendants cite in their reply brief clarified and took sides on a circuit split regarding the effect of the government benefits rule when it came to intended recipients of benefits. So when it comes to intended recipients, if they fraudulently obtain benefits or fraudulently obtain excessive benefits, then the net excessive benefits are the loss. But that's not the effect of the government benefits rule in this case, and that hasn't changed. Unless the court has any additional questions, we ask the court to affirm except with respect to Griffin's judgment. Thank you.
Okay, Mr. Lane, thank you. Mr. Bont, we'll give you, why don't we give you 3 minutes?
Thank you.
It's a big appeal. There's a lot of parties.
Thank you, Your Honor.
Yep.
I appreciate it. I want to first start off by responding to a question that you asked earlier, Judge Scudder, about whether or not there's any case reversing a conviction based on a constructive amendment theory. There is one in the Seventh Circuit that I'm aware of. It's United States versus PG. It's found at 197 F3rd 879, and it's a 1999 Seventh Circuit case. It's cited in the Nantour decision, which we mentioned in our brief. But basically the thrust of those decisions is that the government can limit its theory through its indictment, which our contention is that's what they did here by alleging that the object of the conspiracy was to commit wire fraud affecting a financial institution. Judge Ripple, you asked if this is the way that the government usually charges the case. I would say no. And I think it's important because there is a separate statute here, 15 United States Code, Section 645, which criminalizes making false statements to the SBA. And the existence of a separate statute is something that the Supreme Court mentioned twice in the Cleveland decision as being a persuasive reason why we shouldn't extend a property interest to regulatory fraud. And our contention is that's what the government proved in this case. It proved that there was regulatory fraud, not property fraud. Again, responding to a question that was asked to counsel for the government, there's no evidence in this case that the SBA went back to any of the lenders to recoup payouts that it had made. And I think that's the problem with the back-end fraud theory, as Your Honor has referred to it, Judge Scudder. Because the money was paid out and the financial institutions were made whole, there was no increased risk of loss to the financial institutions. So that element in particular is at issue with respect to the payouts, because the money was actually paid out
possibly.
to the financial.
I mean, part of it may be just outside the confines of the criminal case, right? I mean, is a matter. I mean, it's not clear to me that the criminal case would have to include evidence about the SBA, trying to recoup something from ABC Bank.
Well, I think if the government is going to prove that there was an effect on a financial institution, it cannot rely on evidence that the financial institutions benefited. In fact, their risk of loss was reduced.
Well, no, their argument, which you're challenging. I mean, you're being very clear about that. Is that risk, quote unquote, is not sufficient.
The risk of financial loss, I think, is non-existent when it comes to money that was paid out to the financial institutions. That's correct, Your Honor. Finally, in closing, I will just say that this case bears a lot of similarities to the Cleveland decision. I realize that decision dealt specifically with licenses, but in this case, the SBA guarantee in function was similar to a license, and the specific issue, taxpayer problems with the borrower or the licensee having tax problems was present in the district court during this trial. In fact, it was present in 2 of the loans at issue in the case, which is on all fours with the Cleveland decision. So under Cleveland and Barrero, I think the proper recourse is to reverse the convictions. If there are no further questions, thank you, Your Honor.
Okay, very well. Mr. Bont, thanks to you, and thanks to your colleagues representing the defendants. I understand a couple of defendants had appointed counsel. So thanks to you for your service to your clients and to the court. And Mr. Lane, thanks to you, of course, too. The court's going to take a 5-minute recess, and then we'll continue with the remainder of the arguments this morning. Okay, we'll move to our third argument of the morning, Evans versus Wills. It's appeal number 21-1704. Mr. Duffy, good morning.
Good morning, Your Honors. May it please the Court, Brendan Duffy on behalf of Appellant James Evans. Your Honors, this case is exactly what the inordinate and unjustified delay doctrine is for. Nearly 2 decades ago, Mr. Evans filed petitions for post-conviction relief in Illinois State Court, asserting serious claims of actual innocence and prosecutorial misconduct. Over the next 17 years, the state court process absolutely failed him. Under this court's precedents, a delay of less than 2 years can be sufficient to excuse exhaustion, and this court has called a delay of 4 years extreme. Mr. Evans' case involved a 17-year delay that was largely caused by the state. The district court's decision concluding that only 7 months was attributable to Mr. Evans is clearly wrong, and in fact, the state does not even attempt to defend it on appeal.
And your view is that this district court decision was based only on an inspection of the state docket, am I right?
Yes, and those initial filings that Mr. Evans included in his petition, Your Honor, yes.
Can you tell me about those filings?
Those filings, that included some of the state court filings, but we don't have access to all of them.
I see.
Only some of the filings that he attached to his initial petition.
I see.
Yes. And finally, Your Honors, given the sparse and inconsistent docket sheets, as Your Honor, Judge Ripple mentioned, we think at a minimum, this case requires a remand for a hearing on whether the delay is justifiable.
Mr. Duffy, what's the status of the proceedings before the state court now?
Your Honor, so first I would say that it's our position that that doesn't matter under cases like Vernon and Varner. Yeah,
I understand.
But secondly, it's not altogether clear, as the state court pointed out, that it appears that some sort of discovery has been turned over to Mr. Evans. It's unclear what exactly that discovery is and whether it's all of the discovery.
Has there been any hearing in the state court since the filing of the briefs here?
There is a hearing scheduled for, I believe, the 21st, although the state can correct me if I'm wrong. So coming up in about, I believe, next week.
Do you know if that's a status hearing or is that a hearing on the merits of his?
That is a status hearing. There is no, to my understanding, there is not at this point a scheduled third stage evidentiary hearing.
How relevant is it that there be some state activity at this point? I mean, it seems to me that's just makes this whole thing pointless if the state can, once they're called on an unconscionable delay, do something to stir the pot and not necessarily move the ball along very much. That really makes this whole thing kind of beside the point, doesn't it?
Your Honor, so I'd say two things. On the law, I would say this court was clear in cases like Vernon and Varner that exhaustion of remedies is determined at the time the petition is filed, which I think makes sense for a lot of practical reasons, because you don't want a case like we have here, 2 decades of inordinate, excessive, and really unprecedented delay, and then all of a sudden the state court kicks the process going. This court has repeatedly looked to the course of the state court proceedings to assess whether there has been an inordinate and unjustified delay. In other words, Your Honor's past is prologue. That's exactly what this court has consistently looked to as the best evidence to whether there is an effective state court process.
Mr. Duffy, I'm sorry.
No,
Judge
go
Ripple,
ahead, please, go ahead.
Do you believe the state court itself, as opposed to any of the parties, is responsible for part of the delay here?
I do, Your Honor. Yes, I think there are several independently sufficient delays here. I think we could just start with even assuming they're brief. I think we have 5.5 years, which clearly meets the standard. I think they admit on page 42 of their brief that they didn't turn over certain discovery from 2008 until 2012, and then additionally didn't respond to several years worth of delays. That adds up to 5.5 years. Again, this court in Carter said 4 years extreme. The Third Circuit and Burkett said 5.5 years was enough to excuse exhaustion as a matter of law. So we think we have that. We think we have the discovery delays. And then the third element of delays, which we think adds up to at least 8 years, is the state court's failure and giving inattention to Mr. Evans's case. We think this clearly falls under this court's decision in Carter. This court in Carter said that certain filings should have rung alarm bells with the state court, This court in Carter also said at one point, there seems to be no administrative procedure seems to be in place to detect and end the severe stagnation. We think a lot of what happened with the state court in ignoring certain filings, not scheduling hearings, not responding to filings, all falls under that logic in Carter and should be attributable to the state.
Is there, in Illinois, is there a state policy or is there a policy in this court about appointment of counsel in a collateral attack in a case like this?
There is, Your Honor. So there's a structure in place that provides post-conviction counsel at the second stage of the Illinois post-conviction process.
There is.
Yes.
So the expectation on the part of the petitioner as well as the judge would have been the counsel would have been appointed.
I think that's correct, Your Honor.
I see. Where is this this venue? What part of the state is this?
In Southern District, Your Honor. Mr. Evans is in Menard Correctional Facility.
I see.
Yes. So in just talking about, I mentioned the delays that we think are uncontested in this case that add up to 5.5 years, but I think really the smoking gun here is the discovery issue. So in 2008, the state court ordered the state to turn over certain relevant discovery materials. Over the next 4 years, the state ignored 4 different discovery orders, repeatedly ordering them to turn over.
And what we're talking about are these audio tapes.
We're talking about the Rounds audio tapes, Your Honors, yes.
Anything else?
Yes, there are certain other discovery materials that Mr. Evans has requested.
And as we're talking right now, I'm just going back to the point you made before about some discovery you understand has been produced, but maybe not all.
That's correct, Your Honor.
So what do you know, just to get specific about it, has Mr. Evans received all the audio tapes that he's asked for?
No. I think it's very clear from the records, as late as 2000, just in the state court process, in 2006, 16, and 2017, you can see very clearly on page 178 and 79 of the appendix that he filed motions to obtain those same audio tapes that he never received, even though the district court held a hearing in 2012 absolving him of that previous 4-year delay and saying the state hadn't been clear on who had what tapes. The state thereafter did attempt to apparently...
this was the business about in the clerk's office, they looked in one file but not another file.
Yes.
Yeah.
And
yes,
they
Your
gave
Honor.
it to the guard.
And then the
it
guard,
was
it was confiscated. But thereafter, directly thereafter, Mr. Evans repeatedly made filings saying, please turn over these tapes to me. And over the next 5 years, he did not receive them, as I said, 2016 and 2017. And then when he filed his federal petition, very clear on page 840 of the appendix that he still did not have those relevant audio tapes. Additionally, Your Honor, if there are no other questions, I'll save the remainder of my time for rebuttal.
Okay, very well, Mr. Duffy. We'll hear from Mr. Schneider.
Thank you, Your Honor.
May it please the court. Counsel, I'm Assistant Attorney General Josh Schneider on behalf of the respondent. I want to start with the posture of the state court proceedings, because I think it's really important, turning to Judge's Ripple question about sort of whose job is it to move the ball. Illinois post-conviction review follows a sort of analogous 3-step process to federal habeas review. The first step is a preliminary screening by the court to weed out petitions that are patently without merit or frivolous. If a petition survives that first stage screening, it proceeds to the second stage, where counsel is appointed if necessary, and then counsel amends the pleading as necessary to adequately present the petitioner's claims. So once counsel is appointed, the ball is in the petitioner's court to finalize the claims that he wants the trial court to review. Counsel was appointed in 2003. There was difficulty finding counsel who did not have a conflict due to representing a prior witness in the trials. But since 2014, petitioner has been represented by retained counsel of choice and still has not filed the amended petition that would indicate to the trial court.
But isn't
these are
that
the
because
claims.
he hasn't gotten the discovery yet? It's hard for him to file an amended petition where part of the argument is the Rounds audio tapes were tampered with and didn't disclose the entire conversation if he doesn't have those tapes.
So, no, that isn't the problem. And the reason
Well,
we know
that's what
that's
the state court in, I think it was 2012, in one of the few transcripts we have indicated.
so. What the state court said is the purpose for this. It was reminding the petitioner the purpose of this discovery is just so you can finalize the presentation of your claims. If you know what your claims are, just file your amended petition and then we can look at it. Because in the post-conviction second stage context, we take the allegations as true. And he can either supply supporting documentation or simply explain why that documentation is not available to him at that time. That's sufficient. So here,
Mr. Schneider, I'm very troubled, and given that we don't have a ton of time, I'm very troubled with some of the district court's findings. Let me start with the easiest one. The district court found that the state tendered the requested discovery in 2 months. How on earth could the court have found that, given what we do know, that Mr. Evans first filed the discovery motion in April of 2005. In December of 2008, the state court issued an order requiring the state to produce the tapes. In June and July of 2009 and 2010, the court ordered you turn these tapes over. You still haven't yet. In September of 2010, the state court noted Evans was still waiting for the materials. I mean, I could go on and on.
So here's why I don't think it's.
How could that not be clearly erroneous?
Sure. So the district court, I was looking at the records before, and the records before it showed that in December 2008, the state court orders production of these of the tapes. Everything before 2008 is irrelevant because he's not entitled to discovery at the first or second stage, as the state court makes clear.
Okay, so take December of 2008 as the starting point. Right. In March of 2012, the state court says you still don't have these and it's not your fault.
Right.
2 months and they were, I don't understand.
So in 2008, the court orders the state to produce tapes. In February 2009, the docket shows that they're now awaiting additional discovery materials, which at least supports inference that there are additional materials. Then it becomes clear in
How can you justify and try to support the statement that the state tendered the requested discovery in 2 months, and there's no discussion of this year-long delay, years and years?
Well, our reading of the record is that there were different batches of discovery. Defendant went from asking for what the state had to asking for things that the state didn't have. There's some confusion about what exact materials he wanted. But setting that aside, let's say that all of that delay is attributable to the state for not turning over these materials. Let's say that they didn't turn them over. We know, though, that some of the trial exhibits were not in the state's attorney's office. They were in the clerk's office. It's important to remember that these are trial exhibits from a trial in 1999. So at this point, it's over a decade old. But in 2013, in September 2013, petitioner's retained counsel is granted leave to review those original records, those original tapes. In 2015, Attorney Zhao appears in a change of retained counsel and moves to compel review of those same tapes.
So we're now 7 years after the tapes were originally requested.
And it does not appear that counsel went to the clerk's office to review them. Or if they did not communicate to Zhao when Zhao came on board.
It's your burden here to prove that the delay was justified. The law's pretty clear on that.
It is. I would submit, though, that it's our burden to prove that an inordinate and unjustifiable delay did not render the process ineffective to represent his rights or to protect his rights.
And part of that is proving that the delay was justified.
Well, this gets us to the question of what is the span that's relevant to whether a state corrective process is sufficient to protect a petitioner's rights? Is it only the past? Is it the past and the present? For example, if there had been an evidentiary hearing, if there's an evidentiary hearing tomorrow, is that irrelevant to whether
before
the state corrective process?
Before the state or
before
district?
the state. And if the state court were to hold the evidentiary hearing tomorrow, would that be irrelevant to whether the state corrective process is effective to protect his rights? Here we're in the second stage. Since 2014, in 2014, the state's attorney moved to dismiss the petition. The state court denied that motion, and then has repeatedly been trying to move things to a third stage hearing since then. It had been actually set for a third stage hearing on the agreement of the parties in 2020.
Mr. Steiner, let me ask this question. Let's suppose that this kind of confusion about the Illinois three-step, Mr. Evans is clearly confused about it. I'll grant you that. And let's suppose that we have a record here that's not 17 years long, but let's say it's 34 years long. Let's just double it, okay? And so the docket's twice the number of pages, and it shows this confusion and back and forth and everything that's gone on here. At what point does this process just become ineffective because of the passage of time?
So if it was, again, because we're in the second stage.
At some point, this is a case that's sitting on a state court docket. Right? And at some point you would say, look, what's going on here? Why do we have an 03 case on the docket?
And the docket actually does show some of the state court's dissatisfaction with the pace things are moving at. And I would direct the court specifically to September 2017, when the third stage.
Do you think you'd be standing here if it was a 34-year delay?
So I suspect at some point the state court would have run out of patience. The problem, this is really the problem. The problem is, in September 2017, a couple years before the federal habeas petition was filed, the third stage hearing was continued, and the petitioner's retained counsel of choice was told, you file a proposed order and then we'll schedule it. And then she did nothing for 2.5 years. The state's attorney in 2020 then comes forward and says, let's set this for the third stage hearing. And it's set with the agreement of the parties for a third stage hearing on petitioner's claims for March 2021, but petitioner then asked to continue it. So really the problem is with petitioner's theory, attributing all of these delays that his retained counsel agreed to or requested, is what he's saying is that unless a state court compels him to proceed against his wishes on a petition that his counsel has said they are not ready to proceed on, that the state corrective process is ineffective, which means there's some kind of limit on the patience.
But he's saying they're not ready to proceed because the state hasn't turned over the discovery yet.
That's not what the state court records show. The state court records show that as recently as November 2022, counsel was asking time for his expert to review the exhibits that counsel or previous retained counsel had been granted leave to review in the clerk's office in 2013. I know that petitioner's pro se pleadings say he has not gotten these documents. There's been nothing counseled since Attorney Zhao's request for the trial exhibits, which were actually in the
You
trial
think there's a point in
clerks.
time as a legal matter where our role absolutely is not to supervise state court processes. All we're doing is interpreting a statute here, right? But at some point in time, don't you think just the passage of time gets ineffective? It shows that this is ineffective. I don't understand the limiting point of this. 17 years is troubling. If we get to 34 years, if we get to 50 years.
And we're now at 20.
And so I think, if I may answer briefly,
Yeah, please.
I absolutely agree that if petitioner said, I'm ready to proceed, and the state court did nothing, that would be a problem.
Even if the petitioner is hopelessly confused, he's not trained as a lawyer. He doesn't understand. He doesn't trust lawyers. He's changing lawyers. He's got a whole theory in his head about tapes and all this. What difference does it make?
So if you're represented by counsel, and your representative to the court keeps telling the court, we're not ready to proceed, it ultimately becomes a question of, well, at what point does the court's refusal to bulldoze counsel and say, we're proceeding whether you're ready or not, does that render the state corrective process ineffective? He is free to discharge counsel that he's chosen to retain or retain other counsel, but if the problem is that the state court is not compelling him to proceed against his wishes, I would say there's no point where the state court is compelled, otherwise the state corrective process.
One final question at least for me. Do you believe as you stand here today that your client is 100% in compliance with producing tapes?
I want to be clear. Our office has no actual involvement with the litigation in the state court. We just represent the warden. So my access to what's been happening in the state court is fairly limited. I've been checking the dockets. From my review of the materials and the fact that current counsel most recently, if you look at the docket entry from November 2022, which is one of the more fully descriptive docket entries, counsel says we need additional time to retain an expert to review these trial exhibits. So my read on that is that means that they've got the exhibits and they now want an expert to review them. If petitioner is allowed to opt out of or to begin federal litigation of those same claims, then we will have exactly what the exhaustion requirement is intended to prevent, which is simultaneous parallel litigation of the same claims, looking at the same evidence in federal and state court.
Okay,
And so for
very
those
well.
reasons, we ask that the court affirm.
Okay, thank you, Mr. Schneider. Mr. Duffy?
A few points, Your Honors. So first, as to Judge Scudder, as to your point about at some point does the passage of time just automatically excuse exhaustion, the Third Circuit has held that in multiple cases. On Burkett, 5.5 years. In, I believe, Stickman said it's difficult to envision any amount of progress ever justifying an 8-year delay. So I think this court would be squarely within the other courts of appeals in following those cases. I think that another point here that's important to remember is there's an asymmetry in this case that I think really supports Mr. Evans. First, as counsel conceded, the burden is on the state to establish that over the course of this 17-year delay, that they have come forth with a justification. And two, this court has held that as little as 17 months can be sufficient to excuse exhaustion. So in other words, counsel has to come forth, the state has to come forth and demonstrate that all but a few years are justifiable. And as the state has conceded, there's at least 5.5 years that they have failed to provide any justification for. And so we think that alone is enough to reverse this case for a hearing on the merits below. Additionally, a couple questions that you had for state counsel. One, Mr. Evans had sought the tapes as early as 2005. He sought with the state in 2005. The order did not come out, it's correct, until 2008. And then the court did say in 2012 that none of those 4 years was his fault. The other point that there was some discussion of is this third stage evidentiary hearing. Mr. Evans did not want to proceed, it appears from the record, because he didn't have the tapes that were the crux of his case. He couldn't move to a third stage evidentiary hearing, the main part.
Am I correct, Mr. Duffy? All you're asking is that we require the district court to sort all this out. Seems to me we're trying to have the discussion here that you maintain the district court should have had. Is that right?
Your Honor, so I think there's I think there's two ways to resolve this case. One is a remand for a hearing on whether the delay is justifiable, but we think that is the second best option because of what I mentioned earlier, the asymmetry in this case, because the state has the burden and they have to prove all but 17 months essentially was justifiable, and we think there is clearly enough in the record to reverse on that basis so that Mr. Evans can have a hearing on the merits of his underlying petition. The other thing I would point out, Your Honor, is that the state has not pointed to one case in this court or any other that there has ever been a delay of this long that has not had exhaustion excused. And Mr. Evans has repeatedly pleaded with the court to adjudicate his case. This is exactly what the inordinate and unjustified delay doctrine is for. If there are no other questions, Your Honor, we would ask for this court to reverse and remand for a hearing on the merits.
Okay, very well. Mr. Duffy, thank you. Thank you for accepting the court appointment. Thank you to your firm as well, Mr. Schneider. Thanks to the state. We appreciate submissions. And we'll move to our next argument of the morning. Case number 4 is appeal number 22-1485, the United States versus Jeremy Outland. Mr. Brown.
Good morning, Your Honors. May it please the court. I am Jerry Brown, and I represent the petitioner, Jeremy Outland, in this matter. The issue before us this morning is the district court's ruling that Mr. Outland had validly waived his Miranda rights prior to being questioned by Detective Weiss in connection with an arrest for heroin possession. The posture of this case is a bit unusual. This is the second appeal of the matter. There's a previous ruling, as I'm sure you're aware, where the issue of the voluntariness of the statement was addressed, but the court noted the absence of a determination as to the validity of the Miranda waiver. The district court relies for its conclusion that the Miranda waiver had been valid on its belief that Mr. Outland had, prior to the discussion with Detective Weiss, had said to a Springfield police officer who was guarding him in his hospital room while he was being treated for heroin intoxication that he wanted to speak. The language in the suppression hearing transcript is he contacted.
You relied upon that. I read your. I follow your argument just
Okay.
fine. I don't see that that's the basis for the district court's, ultimate ruling against Mr. Outland. There's no question that she makes that observation, but I don't think that's the substance of her ruling, that there's a knowing, an intelligent waiver, a voluntary waiver right up front. That way, I think that's just part of the fact pattern.
But if we look at the language of the court's order,
Right. What page are you on?
I'm on looking at the appendix on page 141. Because defendant asked to speak with Weiss of his own volition without being subjected to any unusually intense pressure from law enforcement, the court finds that defendant's Miranda waiver was voluntary. So the district court does
there's a lot
elevate.
that precedes that, though.
True, because at the earlier stages of the litigation of the case, the primary focus had been, one, was Mr. Outland so impaired by the heroin intoxication and the medication given to him to combat the the intoxication. From the evidence that was presented, the court concluded that the impairment had not been so great.
So when you go, Mr. Brown, to page 14, what the district court there is saying is that, literally, word for word, the most important evidence of the defendant's mental capacity at the time of his Miranda waiver, etc. And then she itemizes it. Right? She talks about what she heard when she listened to the recorded interview, observing that he sounded awake, etc. You know the order.
Yes, I do.
So that, I understand your argument, but it seems to me that what you're focused on, one dimension of what she said to the exclusion of all of the other care that the district court took to look at the totality of Mr. Outland's, mental state at the time that he received the warnings and chose to speak to the police.
And I guess the issue here is that when the court elevates in importance their belief that the reason they conclude that Mr. Outland was sufficiently competent to meaningfully and properly waive Miranda was the previous request to speak to law enforcement.
Let's assume, Mr. Brown, that you're correct. Let's assume that the district court erred by considering Weiss's testimony about what the other officer would told him. How do you get around the district court's detailed and careful ruling based on the interview and the audio itself, which we have listened to?
Your Honor, I acknowledge that, for the sake of argument, if the Springfield officer had testified at the suppression hearing that Mr. Outland told me he wanted to speak to Detective Weiss, I would not be making this argument. And I further acknowledge that in light of the discretion that is afforded to the district judge, the district judge is entitled to make a finding based on the totality of the evidence of the medical treatment as to whether that impairment had been sufficient to make Mr. Outland incapable of meaningfully waive his Miranda rights. We disagree with that conclusion, but I do recognize the standard we would have to overcome to achieve a reversal on that point. But to that point, I would raise the following. In its discussion of how Mr. Outland presented himself during the discussion with Detective Weiss, on one hand, the court concludes that as evidence of his lack of impairment, that he was lucid, that he was coherent, and he showed a very good quality of memory for detail. And then when it comes to his denial of having requested to speak to law enforcement, at the very next breath, we don't credit Outland's testimony because of his poor memory. You can't say at the same time he has a good memory.
But
and
isn't
he has
she talking about different points in time?
Actually, they're talking about the same interview with Detective Weiss. So we're saying that we think he was competent because he's coherent and he's showing a good quality of memory, but when it comes to things that he's disputing, well, we can't credit his testimony because of the poor quality of his memory. It can't be both ways. So I do recognize that this court is not putting a great deal of weight on the district court's connection to the outer court statement to Detective Weiss that Mr. Outland had wanted to speak. But that is the record we have to work with. The judge said that was why she made the conclusion.
I guess my overarching reaction to that, Mr. Brown, is I think it's just irrelevant. So in other words, if what you're trying to say is I think it's exceedingly unlikely that a guy using and dealing heroin is going to come out of a stupor in the hospital and the first thing he says is, "Can you bring the detective in here? I'd like to tell him about my heroin dealing." If that's what you're trying to say, yeah, that seems odd to me too. Okay? Alternatively, go to the opposite end of the spectrum. Suppose the police were just chomping at the bit to get in the medical exam room, and they kind of snuck in or urged, they just made their way in there. What difference does any of that make? Why don't we look at what happened with the delivery of the Miranda warnings and what condition was the defendant in mentally in terms of being able to make a voluntary, knowing, and intelligent waiver? Isn't that the right inquiry, regardless of how the interview came about?
Again, and my fear of going in circles in response to your question, I guess I'm putting a great deal more weight on how the district court presented the rationale for its conclusion. The court said it is because of the request that they concluded that his waiver had been voluntary. While one might question as a factual matter how relevant that is relative to the rest of the record, the fact is that is the court's order, and under different circumstances, I would be hesitant to urge this court, for example, to look at a professed causal relationship in a court's order and ask the court to simply read the language out as irrelevant. The court did say it, and whether the court intended for it to take on the weight that I'm putting on it right now, I guess, is an open question. And I guess because of the posture of this case, there is a context that's relevant here. Because this was on remand, and the previous panel requested that the district court make its determination about Miranda on the same record without taking any new evidence, the focus of the previous round of proceedings really did just focus on the level of impairment because of the heroin ingestion and the medication. So since this question had not been highlighted as significant, there really wasn't much of an opportunity to develop a substantial record on this point. So then once the previous panel directed the district court to make an explicit finding on Miranda, the court felt it necessary to support its conclusion by connecting it to its belief.
Yeah. Okay.
That-
We'll give you a minute on rebuttal.
Okay.
But we understand your submission. Thank you.
Thank you, Connor.
Okay, Mr. Boyle, good morning.
Good morning, Your Honors. May it please the Court, Counsel, my name is Catherine Boyle on behalf of the United States. Your Honors, here the District Court correctly determined that the totality of the circumstances demonstrated that Mr. Evelyn executed a valid waiver of his Miranda rights. I'd like to just touch briefly on knowing and intelligence, since that was sort of the focus of the Court's opinion in remanding the case. The District Court correctly held that Mr. Outland's Miranda waiver was knowing and intelligent. In other words, that he understood the nature of the right and the consequences of abandoning it. The Court's analysis was thorough and detailed and grounded in its factual and credibility determinations, which this Court, of course, reviews for clear error and gives the Court's great deference, respectively. Mr. Outland raises no meaningful challenge to this determination on appeal. The Court correctly found that the audio interview showed that Mr. Outland was wide awake, he was alert, he spoke clearly, he exhibited a range of emotions, he gave great detail regarding his past drug transactions. The Court acknowledged there were a couple moments of slowness or a couple moments of mumbling, but found that overall it was a very coherent interview, and actually Mr. Outland's demeanor reflected his demeanor at the suppression hearing as well, which the Court found to be important. Notably also in terms of his understanding of the Miranda rights, the Court noted that Mr. Outland actually referenced those Miranda rights and coercion issues about 40 minutes into the interview. The medical records supported this. Mr. Outland had first ingested heroin between about 10:06 and 10:44 a.m. when he was taken to the St. John's ER. By the time Mr. Outland was alleged to have requested to speak with Springfield police, there were no issues with his competence. He was viewed as wide awake, coherent. The hospital had done multiple checks. He had been given certain medications, Narcan, Revia, and Zofran, but those medications were intended to counteract the effects of the heroin that he had taken. And the Court's overall analysis shows that to the extent the Court's discussing that he didn't seem to be too impaired to give knowing and intelligent consent from the heroin, that analysis also applies to how his demeanor might have been affected by these sort of counteractive drugs. The Court appropriately found now Detective Weiss's testimony credible. It was consistent with the audio and medical records. He showed a lot of voice modulation. He described Mr. Outland as very coherent, very detailed, and he said that Mr. Outland requested to speak with him. And as it relates to the point I'll discuss in a little bit more detail regarding the voluntary nature, I think it's important here to note that first of all, Your Honor made a salient point as to whether it even mattered, given that we saw a proper Miranda waiver when Detective Weiss came in. But there's also indication in the audio recording that this had actually occurred, because you have then Officer Weiss reading Mr. Outland his Miranda warning, and then shortly after that he says, I heard you have a lot to tell me. I'll put the ball in your court if you want to start talking. And that to me is very strong record evidence that Mr. Outland had requested the interview.
Yeah, you're right about that. That's right at the outset of the interview, right?
It's right after the Miranda warning, yes. And Mr. Outland sits there and doesn't say, "Hey, wait, I didn't ask you to come here," And understandably, there's pressure involved in those situations, but that would have been a moment where he could have said, "No, I don't have anything to tell you," particularly given that he had just received a thorough recitation of his Miranda rights. And the district court's findings and all of this, that Mr. Outland wasn't credible, were really very well founded. I mean, Mr. Outland said at the suppression hearing that he hadn't ingested heroin that morning. He said he had taken some via a needle prior to the stop, and he had admitted that both on the audio interview and in his own motion to suppress. So the district court kind of came in evaluating Mr. Outland's credibility from that perspective, and also noted that Mr. Outland's memory appeared to be clear when it was self-serving. And I think, Judge St. Eve, as you noted, the court's criticism of Mr. Outland's memory as to that was really related to his testimony at the suppression hearing. The court was describing Mr. Outland's memory as clear during the audio interview, and then said that it showed self-serving statements and seemed patchy at the suppression hearing, and that went towards its credibility determination.
There was selective memory at the suppression hearing.
That's a better way to phrase it. And the court, which was in the best position to make this evaluation, also suggested that Mr. Outland's demeanor showed that he wasn't credible at the hearing. Touching again on the voluntary statements, which I've sort of started to do already because this analysis overlaps a little bit, it's interesting that we're here, and it's an interesting procedure, as defense counsel noted. It's a situation where this court has already determined that overall Mr. Outland's statements were voluntary and that there was no evidence of police coercion. And we've addressed the voluntary issue despite the court's focus on the knowing and intelligence of the waiver in its opinion, because the district court came back and Mr. Outland had touched on it in his briefs. But there is already that overarching finding that we go into this with. And there's really nothing specific to the Miranda waiver to show that this wasn't the result of free choice and that Mr. Outland was coerced in some way. I think, as I said, there's significant record evidence that the Springfield police officer did contact Officer Weiss and say, hey, Mr. Outland wants to speak to you, which is really the main argument that's brought forward on appeal. And consistent with my other points regarding the knowing and intelligence of the waiver, there's really no other evidence in the record to suggest that this was not voluntary. If your honors have no further questions, we'll rest on the arguments in our brief and ask that the court affirm the judgment of the district court.
Okay, thank you, Ms. Boyle.
Thank you, your honors.
Yeah, Mr. Brown, we'll give you a minute.
Thank you, Your Honors. So as not to revisit territory we've already covered, I do want to make one further point, however, about the underlying statement to Springfield Police. It is noted that there is a requirement that there be sufficient indicia of reliability for out-of-court unsworn statements here. However, the standard of this case under Illinois versus Allen is that every reasonable presumption is to be given against the forfeiture of a constitutional right. Our position is that while police officers can be unnamed sources giving hearsay, they are still subject to that standard of there being sufficient indicia of reliability. And in this case, without sufficient detail to establish those sufficient indicia of reliability, we fall short of the standard required by Illinois versus Allen. Unless there are further questions, we request that the court reverse the lower court and remand.
Okay, Mr. Brown, thank you. Thank you for accepting the court appointment representing Mr. Outland. Ms. Boyle, thanks again to you. We'll take the case under advisement.
Thank you, Your Honors.
Our fifth case of the morning is appeal number 222236, Dennis Bakke versus the Commissioner of Social Security.
May it please the court, good morning. Dana Duncan on behalf of Dennis Bakke. This case is as factual as any case that I've ever argued before this court. And I'm going to probably indicate right off the bat, if the decision had been rendered in the summer or early fall of 2019, the judge did everything correctly. The problem comes in that it does not reflect the entire record. In this particular case, we had a myelogram that showed that he had renewed stenosis. I'm not a doctor, but I'll try to work through this. He had multi-level fusion. He was noted progress. He said he was feeling better. He started undertaking certain activities, but then it kept getting worse and worse. And then ultimately they did an EEG, which showed some abnormalities. And then subsequently a myelogram that showed that he had stenosis in the very areas where the fusion had occurred. And after some research and using of medical journals and the Mayo Clinic website, it appears what ended up happening is he developed osteophytes over his fusion hardware. And that is what is causing the stenosis. His doctor, as a result of this, limited him to part-time work. And as a result, he would qualify at his stated age for disability benefits.
So to put this on the timeline, Mr. Duncan, that you're starting with, you're saying that in either sometime in 19 or 20, this stenosis developed, and this is what Dr. Andrea Peterson diagnosed?
Correct.
Is that where we're at on the timeline, though?
Correct. While he was in recovery, he had not been released from work, and then all of a sudden he started having these problems, and they kept getting worse. He went out for a consultation to a doctor. The records aren't really there saying what the consultation was, but they did not recommend further surgery because what surgery is going to be available? I mean, we're talking about the potential of taking out the hardware or trying to remove osteophytes from the hardware. So there just wasn't an option. The problem comes in that if on this record he had walked into my office with everything perfectly laid out, I probably would have recommended filing a new application. But he has a date last insured that expired before the ALJ's decision. And he has no opportunity to file another claim for Title II unless he goes back to work and earns enough credits to extend out his date last insured. So it's ultimately, and this, the judge never addressed the myelogram. It's never mentioned in the decision. It's not discussed. So it's either one of two things. Either the judge ignored it, which is contrary to the precedent of this court, or the judge interpreted it and said it doesn't have any bearing or any meaning, which is also contrary to the precedent of this court.
Mr. Duncan, the record shows that Dr. Dukoyski saw the myelogram, but he didn't recommend anything after reviewing the myelogram. He didn't say you should have any follow-up scans. There wasn't anything. So how does the myelogram undermine what's in the record prior to the time?
It's for the simple fact that it's Dr. Peterson who was actually overseeing it, and he didn't have any recommendations other than to review it, but Dr. Peterson did. I mean, it's his silence. I don't know what you can interpret. Is his silence that he doesn't think there's a problem? Well, the myelogram itself said that there was stenosis and outlined the specific findings. And then the doctor who is treating him and overseeing his care at this point, Dr. Peterson, says, yeah, this is the problem. And the judge says her opinion is unsupported by the record, but yet she repeatedly points to this myelogram in the decision and writes into the checkbox form information about the myelogram, and it's never addressed by the judge. Instead, the judge relies on a bizarre, and I'll use that term, record from early in 2020, where if you look at the nurse practitioner who had been doing his follow-up here, she's talking about him reporting pain, having to have stronger pain medications, having all this. And then there's this one entry where it's talking about him farming and going out and doing, tapping trees for syrup. And then the next entry from that same provider goes back into going about how bad his back is. It's just this one entry that just seems like an oddity. And where it came from, I don't know. But that's the record, and that's the one that the judge pointed to as saying that his condition was not as severe as it really was. And it's just an abnormality. The judge didn't outline any of the case law, or excuse me, any of the medical records before or after this entry, just focused on that one date. The record, as I laid out in my reply brief, shows he sold his farm like a year and a half before this date. So, you know, the idea that he's farming, I don't know where. I had asked him that question. He said, no, I don't know where this came from at all, and it's inconsistent with what I read. Now, this raises a question that probably should have been addressed, and that is, if the judge really felt this that record was a credibility issue, he had a duty to make inquiry under SSR 16-3P and ask about it and deal with it and ask for an explanation from Mr. Bakke as to what this record is or what it means. But ultimately, this case comes down to the simple fact that everything hinges on the judge's handling of that myelogram. And on that point, that's where the case rests. It was the basis for denying Dr. Peterson's opinion. It was the basis for finding him to not be as credible. Other than that, I guess I can't say anything more. I will reserve my remaining time unless there's any questions.
Okay, very well. Thank you, Mr. Duncan. Ms. Cohen, good morning.
Morning, Your Honors. Good morning, Your Honors. My name is Emily Cohen, appearing on behalf of the acting commissioner in this case. Your Honors, I'd like to directly go to a point that Mr. Duncan just raised, that the ALJ did not address that myelogram from August 2019. And that's just simply incorrect. At page 21 of the record, the ALJ addresses it explicitly. Now, he does refer to it as an MRI, and we note in our brief that that is incorrect terminology. But there was no other test at that time with those findings. So the judge must have been referencing the myelogram. To say that the ALJ ignored evidence after the summer of 2019 is simply incorrect. But the ALJ, as we noted, did not interpret that evidence as a layperson, rather correctly relied on the interpretations from Dr. Dukowski and Dr. Peterson. Now, as we noted, Dr. Dukowski did not make any recommendations after seeing that myelogram and characterized it as stable, noting the fusion was still in place.
It's clear he saw the report on the myelogram, am I right?
Dr. Dukowski,
Yes.
Your Honor? Yes, Your Honor. Let's see, there's a page, I believe it's 637 in the record.
Mm-hmm.
Dr. Peterson also reviewed that myelogram. Dr. Peterson was the one who ordered it. And it is true that Dr. Peterson talks about those findings in several of her treatment notes. But as the district court found, simply reciting those findings in Dr. Peterson's treatment note made no indication that she was relying on those findings to draw her opinion. Moreover, in subsequent examinations with Dr. Peterson, Mr. Bakke then said that his pain was rated as a 3 out of 10, and his examination with Dr. Peterson in June of 2020 was nearly entirely normal. And Dr. Peterson did not recommend any treatment other than medication, injections, and physical therapy, all of which this court has characterized as conservative treatment in Prill v. Kijikazi. So like this court's recent decision in Durham, which is instructive here, the ALJ relied on the doctor's interpretations of the test results, not the ALJ's own lay interpretations of the test results.
Ms. Cohen, can I tell you a question that I have on my mind from reading this a little bit? It's not what I wondered about with the RFC, the light work determination, was whether it's deficient for not being accompanied by some sit-stand limitations. Okay, so in other words, even if you're correct that the light work determination is supported by substantial evidence, okay, at a more granular level, what I wondered about is whether he did show sufficiently that, he just can't work an ordinary 8-hour day without some accommodation on sit-stand. And I'm not seeing either party really talk about that. There are some things in here, the standard stuff, you can't climb ropes and ladders and stuff like that. But when I read the ALJ's opinion, one of the things that seemed to stand out to me, you can correct me if I'm wrong, and I might be, okay, is that Dr. Peterson thought or observed that, he really does need to alternate between sitting and standing. These are not made up back problems. I mean, he's got some serious back issues here. And then it looked to me like I don't know if maybe the combination of Doctors Yun and Nimagata thought that there needed to be some postural limitations. And then, of course, you have the claimant himself that is testifying about the difficulty he's experiencing with walking, standing for long periods of time. So that's the question I have.
Well, Your Honor, I would submit that when the ALJ evaluated Dr. Peterson's opinion, the ALJ outlined multiple reasons why the opinion was not persuasive, and including in that opinion was the opinion that Mr. Bakke needed to alternate between sitting and standing. The ALJ was not required to individually discuss the persuasive value of each and every limitation in Dr. Peterson's opinion, but substantial evidence did support his determination that the opinion as a whole was not persuasive, including the sit-stand option.
Yeah, and that's, if you're right, the last point you made is the key one. Where I thought the problem with Dr. Peterson is the ALJ just thought the overarching conclusion is problematic coming from Dr. Peterson. In other words, Dr. Peterson's the one that filled out that form, right?
Correct, Your Honor.
I don't know what that thing's called, ability to work form or whatever, that way. And said, I don't think he's capable of working. And then offered the opinion he can only work 4 hours that way. Okay, I understand discounting that, under the standard of review under which we're operating, but what about a limitation? What about some kind of sit-stand limitation? Because I looked at this and maybe Mr. Bakke can work an 8-hour day, doing light work, maybe sedentary work, I don't know. But it does seem like he's going to need some ability to adjust sitting and standing, given the back problems.
And Your Honor, that's a fair assessment, but neither Drs. Young or Nimagata, addressed or thought a sit-stand option was required. Yep. And Mr. Bakke's own testimony...
Is that different than postural limitation? It may be, I don't know.
It is, Your Honor, yes. Sit-stand would simply be the alternating between sitting and standing, whereas postural is climbing, stooping, kneeling, crawling.
Are these terms of art, like in the...
They are, Your Honor, yes.
Right, okay.
Yes, and those terms are defined in SSR 8310 as well as the non-exertional limitations.
Didn't they say he could sit for 6 hours of an 8-hour workday?
Correct, Your Honor.
And was that limitation incorporated
in the RFC?
In the RFC?
Yes, Your Honor. So standing for 6 hours out of an 8-hour workday is equal to light work as it's defined in the regulations,
okay.
404.1567B.
Oh, it's built into the regulatory definition of light work.
The amount of standing in a total day, yes, Your Honor. And SSR 8310 also goes into greater detail on the standing requirements of light work. To address the point that plaintiff's activities or the ALJ overemphasized statements that Mr. Bakke made, about his activities to Ms. Zellner at page 644 of the record. The suggestion that those statements stand alone is simply not true. As we say in our brief, it actually coincides with many differing statements that he made to his physical therapist and other doctors, that he was at one time riding a tractor or hunting deer or snowshoeing and tromping through the woods in deep snow. I mean, these are very robust activities for someone to undertake after they've had a fusion surgery. And as far as the argument that the ALJ had a duty to inquire about that statement, that is true, but the ALJ did so at the hearing. Mr. Bakke discussed at length his activities and what he could do at the hearing. So there was no ambiguity in the record. And while the ALJ may not have addressed every single one of those limitations in the decision, the fact that Mr. Bakke made inconsistent statements in his testimony at the hearing and inconsistent with the statements he was contemporaneously making to doctors, the ALJ had a duty to resolve that inconsistency, and that's exactly what the ALJ did here. Your Honors, in closing, I'd like to address that the ALJ accepted the opinions from the state agency reviewing physicians. Other than one environmental restriction, the ALJ's restrictions were actually greater than those doctors, and nothing that Mr. Bakke has raised would call into question the substantial evidence underlying the ALJ's decision. For those reasons, if Your Honors have no further questions, the Acting Commissioner will rest on her brief.
Okay. Ms. Cohn, thank you very much.
Thank you, Your Honors.
Mr. Duncan, you had some time left.
The ALJ relied on the state agency physicians who never reviewed the myelogram. And the only doctor who really has provided any assessment in this record of what that myelogram is and what it means was Dr. Peterson. And while the commissioner argues that the ALJ did address the myelogram on page 22, I'm looking through there. I mean, these are fairly significant findings on that myelogram. Why would, if the judge is really considering these, why would you not have put them in there? Why would you not state why you think these aren't important? Instead, we're kind of left to guess. And as this court said in Moon, if you have to scour the record to find justification for the ALJ's opinion, you reverse. And as far as the rest goes, yeah, there were times where he felt good. People have good days and bad days. He's not working. He's taking pain medication. He doesn't have the demands associated with work. And as far as what the restrictions are, I mean, I can tell you right now from experience, a sit-stand option at will for somebody limited to light or sedentary work generally will be described as unemployable by a vocational expert, because work requires you to be at a position long enough to perform the tasks. And if on a bad day, Mr. Bakke can't stand at a photocopy machine for more than 2 minutes, and he's got a whole project to do in this office helper situation, he's not going to remain employable.
So, Mr. Duncan, you got a lot of experience in this area. When we see like sit-stand limitations, they tend not to be associated with light work. They're with other kinds of work.
It's on top of it. Light and sedentary work is described within the regulations and in the Social Security rulings. Light is 6 hours standing, at least 6 hours sitting. Sedentary is no more than 2 hours of standing, or 3 hours, approximately 1/3 of the day, and 6 hours of sitting. And where you talk about a sit-stand option is that you have the ability to go up and down.
Yeah, it's just kind of layered on top of that.
And if you're in a sit-stand option automatically, you're going to potentially not be able to do a light job, because you may end up having to sit more than the 6 hours for a light occupation. And as a result, that's the problem we have in this.
So your point is that when you with VEs tend not to testify, yeah, you're fully employable with a full flexible sit-stand option on top of light work. You don't see that.
Not very often.
Okay.
And if it was, I would be challenging it. So thank you.
Okay, very well. Thanks to both parties. We'll take the appeal under advisement. We'll move to our final argument of the morning. Appeal number 22-1799. The United States versus Daryl Rowland. Mr. Leon, good morning. We'll begin with you.
Thank you, and may it please the court. This court should vacate the district court's order and remand because the district court clearly erred twice in failing to hold a Franks hearing. First, the district court's one-sentence analysis regarding Franks failed to address the most material piece of evidence in the record, Detective Shu's affidavit. And then second, after failing to address that affidavit, the district court erred again in ruling that Mr. Rowland was not entitled to a Franks hearing. And I think because the first error led to the second, it's really important to understand it and start with it. Below, the district court never analyzed if Mr. Rowland's alleged omissions actually satisfied the two-pronged Franks test, which here is materiality and recklessness. Instead, the district court stated that although Mr. Rowland alleged Officer Lewis recklessly omitted material information, he failed to offer any proffer or evidence. In other words, we had allegations, but no evidence. But at pages 4 and 5 of my reply brief, I provide a chart for the court to show that Detective Shu's affidavit, in fact, supported every alleged omission that we urged below in the district court. And to be blunt here, Your Honors, the district court cannot fail to address the most material evidence in the record and then rule that we have no evidence in the record. That's a clear procedural error. So now we're on appeal in a posture where the district court hasn't considered the most material piece of evidence in the record. I cannot find any case in this court's precedent in which the district court fails to consider the most material piece of evidence regarding Franks, and then this court not only applies Franks in the first instance, but then addresses the exclusionary rule as well.
Mr. Leon, let me tell you what's on my mind from reading your brief, and that is you lay out the different omissions at a couple points in the brief, and when I look at them, I think, okay, but why does that undermine the search of the car in any way?
So, Your Honor, that's the second part of our argument, and I'm going to address that. But that's really a two-step analysis, right? And the part you're getting at is the probable cause inquiry, and you have to consider the precise legal question here, which is very important. The question is whether the evidence that the officers found showed or had a substantial chance of showing that evidence leading to the real shooter of Banks would be in the Buick. That's the precise question. So now when you consider...
Isn't the question a little bit different than that? Isn't the question whether or not the search warrant, whether or not there was probable cause to believe there would be evidence of a crime in the car?
Yes, Your Honor, and the Supreme Court has defined evidence of a crime in this context as evidence leading to a criminal. And the only criminal at issue here when they applied for the search warrant was the shooter of Banks. So we have to ask whether evidence leading to the real shooter of Banks would be in the Buick. But when you consider the omissions here, the victim, not Mr. Rowland, but the victim, explained to the officers that Mr. Rowland had nothing to do with the shooting.
Well, that's a pretty narrow view of what the crime could be in a situation like this, right? This is in the middle of the night in an emergency room. The police they know there's a guy shot there, so you're absolutely right about that. But they don't know anything about the circumstances. They know what people have told them, okay? But they haven't had time to undertake a full inquiry. Maybe they're going to learn, later on that morning or in 5 minutes, somebody's going to tell them, you know what, that guy at the emergency room we think was involved in that shooting on this street corner or in front of the 7-Eleven or whatever. That way, there was a shootout that way. We don't have any idea. So I don't know that we can, when we evaluate the warrant, and we're thinking about stage 1 and stage 2, as you're doing of Frank, that we can define with a lot of precision, or maybe more accurately, that the Constitution requires us to, what the crime is. It could be a lot of different things.
That is correct, Your Honor. It could be a lot of different things, but the officers here and the government has only pointed to one potential crime that they could have had probable cause for. So we have to consider it in that context. And when you consider it in that context and you consider the omissions at issue here, again, they showed Rowland had nothing to do with the shooting, nothing to do with the shooter, and was not at the...
According to who?
I'm sorry?
According to who?
According to the victim.
Right. Do the police have to take their word at that?
Of course not, but they have nothing else to suggest otherwise. It would just be
Well, they
suspicion.
got blood in a car and they got 2 guns in a car.
Yes, Your Honor, and we argue that blood and guns are not always per se evidence leading to a shooter, and you have to consider context.
But you seem to be arguing that they have to show probable cause to believe that Rowland was involved in this crime.
No.
And they're not searching Rowland or arresting Rowland, they're searching the vehicle.
No, Your Honor, we're not arguing that. We're arguing that they needed evidence, or they need to have a substantial chance of finding evidence in the Buick leading to the shooter. Yes, the victim's statements here exculpate Rowland, but they also show that his car had nothing to do with the crime scene. That's the second key part here that the government fails to address, is that how can evidence leading to a shooter be in a car that had nothing to do with the crime scene?
Let me adjust the fact pattern on you a second, okay? And
Sure.
'cause I'm interested in how you'd analyze this. Let's suppose, for instance, that after the police showed up, Mr. Banks is being attended to by the doctors and what have you. Mr. Rowland says, I'm going to head home. And he's ready to drive home. Would the Fourth Amendment compel the police department to allow him to get in his car and drive home?
I think the answer, Your Honor, is whether they had probable cause to search it. And we submit no, because he had nothing to do with this crime scene. His role that night was limited to one thing.
Here you are back to
According to
Mr.
who?
Rowland, though.
Yeah.
Yes, but it's important to understand that Mr. Rowland only went from a location away from the crime scene to the hospital.
But it's not what Mr. Rowland did or didn't do.
That's-
It's whether or not the car, when a victim of a gunshot wound at 3 o'clock in the morning shows up at the ER and there's blood and guns in the car. It doesn't matter if Mr. Rowland was involved in it at all.
In part, it does, Your Honor. I disagree, because once you exculpate Mr. Rowland, the next question is what Your Honor is getting
Yeah,
at.
see, time doesn't allow the circumstances don't allow the exculpation of Mr. Rowland. They allow Mr. Rowland to offer his account to tell the police but how do the police know what happened here? They don't. They know they got a guy in a hospital that's shot who said, my buddy Rowland drove me in here. Rowland told the police but the police don't have to just accept all that.
No, and I think we're going in circles at this point, Your Honor. I do agree that the police do not have to accept it, but they need something else to show so, right? They can't just guess and then go search his car. That's not what the Fourth Amendment allows. They have to have a fair probability or substantial chance that evidence
So what if the argument is no more than the victim's blood, the victim of a shooting, we believe, his blood is in the car. That's evidence of a crime. Okay, it's in the car, and we need to get a warrant.
So two things, Your Honor. It's not evidence of a crime as the Supreme Court defined it. And even the officers here
When
suggested
you say
that
Supreme Court, what do you have in mind?
Hayden and his progeny. And to be clear, even the officers here,
Hagen?
Hayden, it's a Supreme Court case. I cited in my brief, the reply brief. So, but to be clear here, even the officers, after they searched the car, they released it to Mr. Rowland's girlfriend. If this was evidence of a crime, they would have kept the butte. They would have impounded it. They didn't need the blood, and there's no way to think that the blood would lead to, one, apprehending the shooter and convicting the shooter. And if the government is right on this point, and I want to make this very clear because I think it's an important point, that any time Rowland bleeds from this shooting wound, it would be evidence of a crime that the government could get weeks after the shooting. The blood itself is a causal result of the shooting, but it's not anything that would be helpful to the officers in convicting a criminal and finding a criminal. And I know that's...
Why isn't it evidence he was shot?
It is, Your Honor, but it's, Rowland
So why isn't that evidence of a crime? If he goes to the ER after he's been shot and his blood from the gunshot wound is in the car, that seems like evidence of the shooting to me.
Yes, Your Honor, but just imagine this situation. Mr. Rowland goes to Walmart after this shooting to get gunshot wound ointment. That's evidence that he was shot. But officers could not go into a house to get this gunshot wound ointment. The difference is it's a causal result of the shooting, but it's not evidence leading to the shooter. And I see that I'm out of time.
Okay, very well. Thank you, Mr. Leon. Okay, we'll hear from the government.
May it please the court, Samantha Spiro on behalf of the United States. This court should affirm the district court's denial of the motion to suppress. The touchstone of the Fourth Amendment is reasonableness, and here it was clearly reasonable for police to believe that they would find evidence of a crime in the defendant's car. The car drove a shooting victim from the area of a shooting, and and that shooting victim had 3 gunshot wounds. Police saw in plain view a blood stain and 2 guns, specifically one which was a MAC-10 style pistol with an extended round magazine and a potential suppressor.
Ms. Spiro, does the record show that the officers were able to see those 2 gun alterations when they observed the firearms through the car?
They observed the firearms, and they observed the 2 extended magazines and what they thought appeared to be a suppressor.
I see, okay.
And so they saw those in plain view. And under Warden versus Hayden, which is what defense counsel just cited, there was a fair probability of evidence being found in the car that would lead to the apprehension or conviction of a criminal. And so under those circumstances, police had probable cause at that point to search the car, and they didn't need a warrant. They could have used the
Talking about the warrant, does the record indicate whether there is a standard operating procedure in Indianapolis that an officer should get a warrant in those situations? I understand he didn't need one, but is there a standard operating procedure that the officers had to follow or should have followed in getting in touch with the magistrate? The reason I ask is your brother suggests to us that there was something nefarious about getting the warrant, and I just wondered if this was just this is the way the Indianapolis police just operate.
So I don't know if it's a standard police practice, but I do know that the statement that there's something nefarious about it is incorrect. The Seventh Circuit precedent, as well as other precedent, does favor police obtaining a warrant, and courts have said that it's prima facie evidence of good faith when they do that. And so they didn't need a warrant. They could have gotten into the car under the automobile exception, but the fact that Officer Lewis, nevertheless saw one is evidence of good faith. And the defendant points to certain evidence or omissions that police left out of the warrant affidavit, but it's well established that police don't have to include every detail that they know in a warrant affidavit. And as Your Honor pointed out, none of those details would have negated the substantial probable cause here. The fact that the defendant drove the victim to the hospital, for example, that was included in the warrant. In fact, it was the only thing that was said specifically about the defendant in the warrant affidavit at all. Regarding the other detail that the shooter was unknown, the warrant said absolutely nothing about the identity of the shooter, and it certainly did not incriminate the defendant. So
do we know the precise time when the officers ascertained that Mr. Rowland was a convicted felon?
I don't know the exact hour and minute, but
Sequence of events.
Yes, they ascertained he was a felon after they conducted an interview with him subsequent to the search of the car. But it's our position that they would have discovered that fact regardless of the search of the car, because they already knew, they saw in plain view that the guns were in the car. And they would have conducted an interview with him regardless because of that, and because he was a material witness to the aftermath of a shooting.
I know he was driving the car. Was he the registered owner?
He was, yes. So I would just finish and say that the warrant said nothing about the identity of the shooter. It didn't incriminate the defendant. Police were looking for evidence of a crime, and they had probable cause to search the car. And then there's also no evidence of intent or recklessness on the part of Officer Lewis in this case. The shoe affidavit does contain additional details that are not in the Lewis affidavit, but those affidavits are consistent with each other. And as I've said, police are not required to include every detail that they know in a warrant affidavit. If Your Honors have no further questions, the United States will rest on its brief.
Very well.
Thank you.
Yep, thank you. Mr. Leon, you want a minute of rebuttal?
Thank you, Your Honor. I just want to go back to what evidence of a crime is under the Supreme Court's precedent. The Supreme Court has said, and this court has said multiple times, that it's evidence leading to a criminal. And in this case, the only criminal that the government has pointed out that there could have been probable cause for was the shooter. And when you consider the omissions and that Mr. Rowland had nothing to do with this shooting, at least the evidence showed so that the officers had at that time, he had nothing to do with the shooting, the shooter, or the crime scene. And he only went from a location away from the crime scene to the hospital. there's not a fair probability that evidence leading to the shooter would be in the Buick.
Okay, very well.
Thank you.
Mr. Leon, thank you very much. Thanks to the government as well. We'll take the case under advisement, and that will conclude today's arguments.